Original side commercial. Item number 1.
Chalo.
Item number 2.
This was not the appeal, not from an order, not passed by the.
Your appeal.
Not, I'm the respondent, not.
Respondent.
It's not. This was not from the order of the arbitral tribunal. Not had indicated this will lie before the single judge. Not.
Yes.
But
And what did the other side say they wanted to?
Yes, Bhavani printers.
Yeah. My friend appears not.
Yes. The main counts. My colleague is also right in the left. I can assist the court while he's on it.
No. You practice here.
No, sir. I'm from Delhi.
Delhi. So here, this court's practice is that appeal from section 17 order goes to a single judge, not to a division bench.
Okay, ma'am.
So
I will request my lord may pass it over because the AOR who has done the filing and all who practices here.
Lordship may permit him to withdraw with liberty to file before the
file it there. Yes.
I understand. Just a part.
I appear for the appellant, my lord. My lord, had been.
You should be acquainted with the practice of this court.
My lord, I was. My lord,
Yes. So what, withdraw it and file it before the single.
My lord, we are withdrawing it.
Then you withdraw it. I mean, it will be dismissed as withdrawn.
Withdrawn, yes. Liberty be given to file it afresh.
Lordship could observe that is from section 17 where the appeal lies before the single.
This appeal is directed against an order passed by an arbitral tribunal under section 17 of the Arbitration and Conciliation Act, 1996. Stop. This appeal should be heard by a learned single judge, having determination in the matter. Paragraph as prayed for by learned advocate for the appellant, appellants. Leave is granted to the appellants to withdraw this appeal and the connected application, which accordingly stand dismissed as withdrawn, with liberty to file the appeal before the appropriate bench.
Deeply obliged, Your Lordship. Deeply obliged. My lord.
Item number 3.
My lord, I appear for the appellant in item number 3, my lord.
Item number?
3, my lord.
3.
Yes.
Mr. Rudraman Bhattacharya is appearing.
Sorry?
Mr. Rudraman Bhattacharya is appearing online.
Why online?
He was suffering from COVID lately. So.
Oh, COVID?
Yes, Mr. Bhattacharya, last week only, Lordship, we have intimated that Mr. Bhattacharya was detected with COVID. And
so now what do you want?
Lordship, he is supposed to appear online, Lordship. If Lordship kindly...
Mr. Shaha, how urgent is your matter?
Well, there is some urgency, but on our last occasion, Lordship had passed an order that Lordship is pleased to hear out the appeal itself on the basis of the available papers.
Okay.
My lord, here the issue is, we had filed for execution of an award.
1 second. The only problem is the connectivity issue.
Yes.
This online hearing of a matter is not very much to our liking. When is he expected to...
Lordship can keep it on Thursday. By Thursday,
he will come.
Thursday,
consult your diary.
I am led by Mr. Jishnu Shah in this matter. He has some preoccupation there, I think, my lord. No, 25th, Thursday also perhaps is not there. 25th.
Any date you give, as per his convenience?
26th, is he there? Do you know? 27th? My lord, Thursday then in that case.
Yes.
Yes, my lord, Thursday in that case, my lord. Otherwise, if he's not there, then I am there to assist.
Yes. That will be sufficient. Thursday? On the request made on behalf of the respondents, let this matter stand adjourned and be listed again on Thursday date thou, retaining its position.
Wait.
This I have. Wait.
Item number 4 and 5.
Lord, I am led by Mr. Banerjee, my lord. Kindly, I request for a short passover, Mr. Shatru Banerjee. My lord,
passover? Oh, Kobelko.
Yes.
Lordship, assignment of an arbitration clause.
Yes, my lord.
Other bench
The other
had-
bench was,
Yes, yes, my lord. Your lordship was hearing it with Justice my lord, Rai, my lord.
Yes,
yes,
in all probability, that bench will be sitting on Wednesday, Thursday. Let this go.
Then,
with-
my lord, will kindly take it up on that day, my lord, because we have substantially completed the hearing, my lord.
yes, my lord.
We cannot unless you get it. Of course,
Then,
Very,
my lord, will kindly
very
keep
well.
it tomorrow,
keep
my lord.
it-
I'll have a word with Mr. Banerjee, then we can make an end of my lord.
Wednesday, day after tomorrow.
Yeah,
Very grateful, your lordship. Very grateful, my lord.
much obliged.
Both matters, 4 and 5, day after tomorrow. This is that incorporating that arbitration clause, isn't
Yes,
it?
yes, your lordship.
The other bench almost fully heard it.
Yes, Mr. Banerjee was dealing with the judgments, my lord.
Yes, all right.
Yes. Grateful.
Item number 6 and 7.
Lordship, I am for the petitioner in this matter. There was a direction to file a paper book, but the last order, but the paper book was duly filed, your lordship. Few pages were illegible, for which we had also changed those pages in the department and incorporated, and we've also intimated the other side of the legible pages which have been changed, your lordship.
Other side, who's appearing?
Mr. Banerjee,
Anyway, Ms.
let it be
Pandey,
not today, your lordship.
not today. Not today.
Item number 8.
এটা order করে না 6-7 টা learned advocate for the appellant says that the pages in the paper book which were illegible have now been replaced. Stop. Paragraph. Nobody appears for the respondent. Paragraph. Let this matter stand adjourned for the day.
Item number 8, my lord, I beg to appear for the appellant. I'm led by Mr. Jayanto Mitra, my lord. Praying for a short passover, my lord. He's on his way. Grateful. Item 8.
Lordship, in the item number 3, I am for the petitioner.
Hey, bhai, ki?
Item number 9.
I am for the respondent, my lord. Mr. Ghosh on the last occasion had taken time.
Yes, we shall be doing the matter. May we begin? Item number 9, your lordship, I am for the appellant.
Do it.
Yes.
Stops you.
Lordship, on the last occasion, Mr. Ghosh was placing some judgments, your lordship. We shall be continuing from that. Yamini Mano. Lordship would kindly take the decision in Yamini Manohar,
I'll just take your lordship.
which had been submitted on the last occasion, I believe. Devahaini. Lordship would then kindly take.
There to note নিচ্ছিলাম কিনা Oh, your 12-way dispensation has been revoked.
Yes, your lordship. That has been revoked and the suit has in effect been dismissed, your lordship. The suit has in effect.
Yes, then he will complete it. Midway, no changeover.
Very well. If lordship is sometimes, sometimes I'm told you please don't ask for.
No, he has not yet started.
Not yet started.
Lordship would kindly
Start করে Yes. Leave me.
Yes, Lordship would kindly permit Mr. Ghosh. Decision there.
অর্ধেক হয়ে গেল কি করে?
Lord, I had placed Milord.
Yes.
The
Srishti he had placed.
Srishti Milord. Let us Milord go back Milord to Srishti in question Milord. Milord, as Srishti I was placing, then Milord the Milord. Because
Yamini Manohar, he handed up just now.
just it's quoted. Lordship will keep that aside for 2 paragraphs, Milord. I'll formally citing it, Milord. kindly have a look at the judgment.
ওই দেখো
I have given Millard
2024 SCC online Calcutta.
Millard, kindly have a look at the division bench judgment in Srishti. Millard, I was reading paragraph number 19 when we stopped. Millard.
Yes.
যেখানে শেষ করেছে ওখান থেকেই শুরু করবে। It's Millard, HTC online printout, it's page number 5, para 19.
Yes.
Under section 12A, a cooling off period is provided for the parties to explore mediation. When a suit is dismissed under Order 7 Rule 11, a fresh suit can be filed, but the court fee is payable over and again. When under section 12A, the plaintiff is compelled to go for mediation, there is a ray of hope that the matter may get settled. It's a win-win for all sides if the mediation is successful. Now, Millard, kindly Millard, takes Millard, paragraph number 22. Rest is on the appellability, Millard. If in the threshold the suit is not taken on board, we are not concerned. Millard, kindly take paragraph number 20. What partial automation did not decide? The facts enumerated below were not before the court and consequentially not decided by it. Millard, this is the division bench. A mediation or the application to file. A case where the defendant has no intention of resolving the disputes by mediation. In fact, he is fairly opposed to any claim by the plaintiff. When a leave is sought to file the plaint without pre-litigation mediation and such leave is granted, he immediately makes an application for revocation of the leave on the ground that the plaintiff ought to have but did not undergo pre-litigation mediation. No urgent relief was contemplated. Para 26. In this period, the defendant is assured that the suit remains suspended and no order can be passed against him. Now, Millard, paragraph 28. If a defendant, while challenging the institution of a suit with 12-way leave, comes up with a proposal for mediation, it could be said that he is approaching the court for revocation of the leave for quicker and effective resolution of the disputes between them and the plaintiff without undergoing long and expensive litigation. But without any proposal for mediation, the objection of the plaintiff obtaining 12-way leave or making an application to revoke it should be viewed with suspicion by the court. May I stop here for a moment, Millard? The defendant has filed an application for revocation. Millard, in terms of this judgment of the Honorable Division Bench, Millard, he should at least, Millard, say, Millard, that he has an intention to go to mediation and how he wants to settle the matter. Otherwise, Millard, the mandate of the Act, Millard, will is not complied with because the mandate says mediation. So if you ask for 12-way, Millard, dispensation order revocation or recalling of the order, the defendant should prima facie, Millard, at least say, Millard, he wants mediation and why he wants mediation. Millard, unfortunately, Millard, the application, which is page 351 of the application of which is volume 3, Millard, is, Millard, absent. There is nothing, Millard, said. On the other hand, the assertion made is, Millard, that, Millard, the plaintiff is now trying to assert this on the ground of, Millard, getting away with the rigors of mediation. Kindly, Millard, takes, Millard, application to the page 351, Lordship will find affidavit in support of the summons, where, Millard, Lordship will not find a whisper regarding, Millard, there is necessity to go to mediation. What would happen, Millard, if there is no mediation and there is an intention to settle the disputes with the plaintiff in question? 351, volume 3, Lordship will see, Millard, there is not a whisper. Now, Millard, if the goods are identical, if the get-up is identical, Millard, what would happen in the mediation? At least, Millard, this statement, Millard, is lacking. Lordship can take it from me, Millard. Paragraph page 351 to 358, this statement is not there. So this was one of my arguments in the court below, which has not been taken note of. Now, my lord, may I continue? It's nothing, my lord. It's there, lordship can take it. Lordship will now come straight away to para 29. Now let us take a look at the sum decision with regard to the meaning which has been ascribed to the phrase if a suit contemplates an urgent relief. A division bench of this court in the case of Gabriel Metal versus Maria Fabricators reported in such and such, para 16 thereof. The legislature, in my opinion, has used the expression contemplated the intention that any interim relief that may be required at the time of filing of the suit or may be required at the time the defendant expressed an intention to do some act to defeat the decree to be passed. So the test, in my opinion, is not whether an urgent relief is immediately required, but whether the averments in the plaint point out to the situation that even before the expiry of 3 months, the plaintiff may have the need to obtain urgent relief. Now, Millard, kindly now take paragraph 30, middle portion, where the Delhi High Court judgment, where Millard Jamini Monohar of the Supreme Court is quoted. Para 9. That's the reason, Millard, I am not placing it separately. We are of the opinion that when a plaint is filed under the Commercial Court Act, a prayer for urgent relief, the Commercial Court should examine the nature and subject matter of the suit, the cause of action, and the prayer for interim relief. So at the time of revocation or, Millard, recalling of the dispensation order, court has to look at, Millard, the subject matter of the suit, Millard. Naturally, then, Millard, you have to show if this type of cases, infringement of a registered trademark, the two products in question. Court has to take, may not go into the merits, but the court has to see the products, that whether there will be possible any effective purpose would be, Millard, to go into mediation. When the statement of defendant to go for going to mediation is lacking, Millard, at page 351. The prayer for urgent relief should not be a disguise or a mask to wiggle out and get over 12A of the Commercial Courts Act. The facts and circumstances of the case have to be considered holistically from the standpoint of the plaintiff, not from the defendant's standpoint. So that's in bold. Non-grant of interim relief at the ad interim stage when the plaintiff is taken up for registration, admission, and examination will not justify dismissal of the commercial suit under Order 7, Rule 11 of the court. At the times interim relief is granted after issuance of notice, nor a suit can be dismissed under Order 7, Rule 11 of the court because interim relief post the argument is denied on merits on examination of three principles, namely prima facie case, irreparable harm, injury, balance of convenience. The fact that the court issued notice or granted interim stay may indicate that the court is inclined to entertain the plaintiff. Now, para 10. This is, Millard, the first part. The second part, having said so, it is difficult to agree with the proposition that the plaintiff has the absolute choice and right to paralyze Section 12A of the Commercial Court Act by making a prayer for urgent relief, camouflage and disguise to bypass the statutory mandate of the pre-litigation mediation should be checked when deception and falsity is apparent or established. So deception and falsity, which is apparent and established. Now, Millard, if a Millard plaintiff comes and pleads a cause of action, say, I give an recurring cause of action 6 months before this suit, and one of the Millard benches finds Millard seeing the product in question, yes, there is no, according to me, it's a Millard discretion. Millard, according to me, there is no chance of going to, there is no useful purpose will be there for going to mediation because the products are absolutely identical. So, Millard, and that is recorded, the date of knowledge is recorded in the order, in the interim order. Can, Millard, the plaintiff be treated subsequently? It's a case of falsity or deception. Because that is the fact which the plaintiff has come. That is the fact, Millard, which the plaintiff has got dispensation order. And that is the fact on the basis which your interim order has been passed.
Even if the products are identical,
yes,
the packaging, the get-up, the defendant may agree to change it in mediation. So why, yes. So it's not that mediation will be totally useless in all such cases.
Millard, that statement should be there in the Millard. That's the preceding paragraph, Millard, in which is unfortunately, Millard, absent, Millard, at page 351 to 358. Yes, defendant can come forward and say in court itself, Millard, that I wish to change my get-up. This is my proposal, or I wish to restrict my territory. or I, my lord, wish to sufficiently distinguish my products in another way. So this is why one should go to mediation. It's not there cannot be a straitjacket formula, my lord. My lord, otherwise, my lord, we would have, my lord, AI robots instead of the honorable judges, my lord, taken up. It's a balancing factor, my lord, which comes in, which AI, my lord, unfortunately doesn't have. My lord, kindly, my lord, takes, my lord, the next paragraph. My lord, I am pressing it because, my lord, that Jamini Monor it's itself here, my lord. The proposition that the commercial court do have a role, albeit a limited one, should be accepted. Otherwise, it would be to the plaintiff alone to decide whether to resort to the procedure under 12A of the Commercial Court Act. An absolute and unfettered right to approach is not justified if the pre-mediation institution mediation under 12A of the Commercial Act is mandatory as held by Party Automation Private Limited. The word contemplate in any urgent relief in section 12A of the Commercial Court Act with reference to the suit should be read as conferring power on the court to be satisfied. They suggest that the suit must contemplate, which means that the plain documents and facts should indicate that the need for urgent relief. This is, so my lord, plain documents and my lord, the case pleaded. This is the precise and limited exercise that the commercial court will undertake. The contours which have been explained in earlier paragraphs, this will be sufficient to keep check and ensure that the legislative object intent behind the enactment of 12A of the Commercial Court Act is not defeated. Then, my lord, next paragraph. Clearly, the Supreme Court established the standard against which the plaintiff and the application for interim relief have to be tested amongst other on the following grounds. 1. The commercial court has to examine the nature, subject matter, and the cause of action the relief sought. 2. The facts and circumstances of the case to be considered holistically from this viewpoint of the plaintiff. 3. The plaintiff documents and the facts should indicate the need for urgent relief. Millard, if this 3 lordship takes it, Millard, prima facie, Millard, when this type of matters are moved ex parte on the first date, 3 ingredients were naturally fulfilled. Otherwise, I would not have got an injunction because it is not a case of Millard, the plaintiff, that Millard, the plaintiff has obtained Millard ex parte injunction by suppression of material facts, by giving a false date. Next, therefore, to dismiss a plaint, a commercial court has to undertake a thorough examination of the case while looking out for deception and falsity. The plaint cannot be dismissed at the threshold for failure to establish the plaint cannot be dismissed at the threshold for failure to prima facie establish urgency. Now, Millard, para 32. Please note, the wording of 12A, the legislature does not mention plaint. It uses the word suit. It employs the word contemplation. Hence, it avoids the words as averment or the statements made in the plaint. In the other words, legislature does not say that from the statement or averment made in the plaint, urgent reliefs obtainable by the plaintiff should be apparent. I would interpret this section as suggesting a fact at the time of presentation of the plaint before the judge from the averments in the plaint and the affidavit to be filed by the plaintiff. It would appear that contemplation of the plaintiff a situation for urgent relief might arise in a period when the mediation has to undergo. The court may allow the plaintiff to institute the suit without mediation. On the basis of the declaration that the urgent relief is contemplated, the plaintiff should be allowed to present the plaint. The court should not ordinarily interfere with such assertion. This is what I placed, Millard. That's the reason, Millard, there is a finding, Millard, in the against me, Millard. As a counsel, I say against me. That, Millard, this was shown basically to avoid the court in question. To, Millard, bypass the court in question. Because, Millard, this paragraph I placed along with the judgment of Justice Sen, Millard, which he, Millard, has a different view on this. So, Millard, 2 different views. So, Millard, I had, Millard, cited, Millard, the judgment of the Supreme Court, Millard. If there are 2 different views,
Earlier view.
Yes, then, Millard, earlier view will prevail. And, Millard, if this is a view which is more narrative in nature or giving, Millard, full, then naturally court sometimes is inclined to follow, Millard. And I cited a Supreme Court judgment to such effect. The Honorable Judge, Millard, said, please don't cite it. Keep it something for myself. That's recorded in the order. The advocate tried, Millard, to bypass the court. This is the paragraph on the basis. Once the plaintiff is allowed to file a suit with pre-litigation mediation, the discretion of the court should not be allowed to be interfered with at the later stage. Otherwise, the proceedings are likely to become dilatory. Even after filing of the suit, the parties can be referred to mediation if the facts so warrant. In the case, although the claim is monetary, there is a pleading since the defendant is incurring heavy loss, some urgent relief may be sought by the plaintiff. So this is exactly, my lord, I say recurring relief, cause of action, this is going on. There is only one line. This is the judge's quoting, my lord, honorable judge. The division bench is quoting rather. Learned judge should have accepted the averments and allowed the plaintiff to institute the suit without section 12A pre-litigation mediation. Instead, the learned judge tried to probe into matter, ambit the merits of the claim at this stage, which was wholly unnecessary. Now, Millard, kindly Millard takes Millard, the Millard concurring view of Millard, Justice Chaudhary, Millard, paragraph 41. Millard, middle portion, Millard, it's Millard. 13 lines from
the
Millard.
question of appealability was also argued in that case, Srishti.
Srishti, yes, Millard, it was held to be appellate. And Millard, the matter went up to the Supreme Court. Supreme Court didn't interfere with the SL.
Under which provision of Order 43, Rule 1 it comes?
It's a decree, it's a deemed decree. It's a deemed decree. I'll show those paragraphs, Millard. I have it, Millard. It was the first point argued, look, there is no decree. It's, Millard, deferment of your right to institute proceedings under Section 9 of the Code of Civil Procedure for 3 months. So there is no decree. Your right to institute the suit is postponed, so it's not a decree, it's not appellable. But, Millard, the argument was where it's appellable under, Millard, Order 43, Millard. Or, Millard, as a decree, Millard, it's appellable, Millard. So that point found favor, Millard. Because it was a dismissal on the threshold, on contest, in the commercial court. I had the occasion to appear, but next stage I was not there because I was not there. Bole dichi. Well, kindly takes line number 13 from top of paragraph 41. In the event the court is of the view that reading of the plaint, the suit contemplates urgent relief, the court should record its satisfaction and finding over the same, which is equivalent to a leave conceptualized in the judgment of my brother, and issue summons on the defendant. On the other hand, he is of the view that no urgent interim relief is contemplated, it shall record a finding and pass necessary orders. Although the order recording institution of the commercial suit and registering the same under Code of Civil Procedure, issuance of summons to the defendant without recording satisfaction about the existence of urgent relief is not bad in law, but there remains an irregularity of such order. As such, as the provision regarding urgent relief is not a pure question of law, but a mixed question of law and fact, the nature of suit and the relief claim must be considered to be determined whether the suit contemplates urgent relief. Moreover, as the conception of urgent interim relief varies from person to commercial suit instituted by incurring huge court fees, should not be initially dismissed for not exhausting mediation where the court do find existence of urgent relief, but the suit should, however, be kept pending and the party should be directed to exhaust the process of mediation. Such orders should be passed upon granting opportunity to the plaintiff to show cause. If the plaintiff disobeys, the suit may be dismissed under Order 7 ruling. So this is, Millard, what the division bench is saying. So far as appellability is concerned, that's paragraph 13 of paragraph 9 and 13 of the judgment in question. 13 tay mark kora chilo. Paragraph 9 and 13, Millard. The Millard or Millard Lordship takes 13. 13 tay nahi. 9, Millard. The question is there at 9.
9 is last and first and perhaps the foremost.
First and foremost. The junior is correct. First and foremost, the objection taken by the respondent in the appeal that the impugned judgment is not, an order is not appellable. This is the issue. Now kindly take, Millard, paragraph 13. The learned counsel for the respondent went to the extent of arguing that section 13 of the Commercial Court Act did not permit any appeal from a decree. No doubt wording of the section is ambiguous in many places, yet it is to be absurd to think that the act dealing with commercial can debar the appeals from a decree, which is final adjudication of the naturally includes the commercial suits. And Millard, this Millard, an appeal was SLP was preferred and the SLP was dismissed. If your lordship copy SLP order to the পেয়েছো এই তো may I hand up? It was not interfered. Or on this point of law, my lord, this was, my lord, appealed from, and this was not interfered. Dismissed as the threshold. Hmm?
Yes.
If your lordship kindly have a look at the Jamini Monohar, paragraphs I am not placing, 10, 9 have already placed, 11. If your lordship takes, my lord, the last portion, the special leave petition, my lord, permitting the suit to continue on a special leave petition from the Delhi High Court Division Bench order was dismissed, which itself shows, my lord, in Jamini Monohar also 12A was not revoked. The dispensation of 12A was not revoked. These are there, but the special leave petition was dismissed with these observations. So, my lord, 12A dispensation order was not even recalled in the SLP stage in Jamini Monohar also. So, the suit remained on the file. But this is the guidelines. And that now, my lord, my duty is to point out why, my lord, this confusion and all these statements in the order. Lordship will kindly take, my lord, Justice Sen's order. এনেছো ওটা বলো তো SRMB দেখছো তো SRMB ডিভিশন বেঞ্চ এনেছো না আনো না দাও আনোনি আছে নিশ্চয়ই আছে আমি দেখিয়েছি লোয়ার কোর্টে হবে ওই তো ওই তো কেন আনোনি very well, I go to Millard, let them Millard take out. Now, Lordship will kindly take Millard. This is the view which is followed Millard, even Millard by different high courts. In this type of matter, Millard, what should be done? This is Kohinoor Seeds Millard. Millard, this is a Telangana High Court Millard judgment Millard. Millard, which Millard says in this type of matter, the urgency and the proposition which is advanced Millard, this was also cited in the court below. বার করে রাখো সময় নষ্ট করো Millard, kindly have a look.
Telangana
Division Bench. Millard, this of course not binding, Millard, but ওটা দেখাবো পরে
We thought you were going to cite some judgment of Justice Sen.
Yes, that I have below. This lordship I cited in the court below.
No, you cite this, no problem, cite this.
Inecho. I'm just giving Millard, they have missed this. I just placed only 2 paragraphs, Millard, because it's on an infringement of a trademark. Millard, kindly have a look at paragraph 18.
18.
1. Or Millard 20, takes it from 20. The plaintiff Veda used 3 trademarks of high quality hybrid cotton and other seeds. The plaintiff claimed reputation and goodwill in the market in relation to the trademark supported by a substantial turnover from the manufacture and sale of the seeds bearing the 3 trademarks in question. The plaintiff Veda sought for relief against the act of infringement and passing off committed by the defendant numbers 1 and 2, Kohinoor and Pistol, of the plaintiff along with the copyright in the registered trademark such and such. The plaintiff's case is also that the plaintiff had business arrangement with the defendant number 1, Kohinoor, whereby the parties agreed that the plaintiff would be the exclusive owner of the trademark Saranand, Tasha and Basant. The plaintiff also claimed copyright in the trade names under the 3 trademarks along with the valuation. The plaintiff discloses the defendant Kohinoor filed a suit against the plaintiff on 2011-2022 in the Delhi High Court alleging infringement of the 3 trademarks by the plaintiff, claiming ownership of the 3 marks. The Delhi High Court passed an order of injunction against the plaintiff on 1/12/2022 prohibiting the plaintiff from using the trademark Veda Sandanan such and such, such and such. The plaintiff avers the defendant number 1 sold the rights related to certain defendant number 2 and further launched its proceeding. The infringement action as specified in the suit and include the advance booking scheme made by the defendant using the trade dress which is identical to the plaintiff's trade dress, exclusive copyrights of the products of the 3 marks. The plaintiff states the suit was filed in with urgency circumstance. The plaintiff accordingly reserves its right to bring further documents. The cause of action pleaded in the plaint is from October 22 to 1st January 2023 when the defendant launched his second advance scheme, and finally on 23/11/2023 when the defendant sold its rights. The cause of action also covers for offering the products from sales from 22/3/2023 to 24/11/2023. The prayers in the plaints are for permanent injunction restraining the defendants from using the artistic work relating to the mark and from passing off the trademarks, and for a direction defendant to render the accounts to misuse against the plaintiff. The plaintiff also prayed for punitive damages against the defendants. The plaintiff Veda filed a plaint in 2023 an application for urgent injunction. The plaintiff prayed for temporary injunction against specifically pleading that the defendant's infringement of trade likely to cause confusion of the unless restraint. The defendant number 1 revisionist would gain unjust competitive edge refusing to the financial setbacks of the plaintiff. The plaintiff also pleaded the prompt action without undue delay. The cause of action pleaded in the plaint would show urgency formed the bedrock of the statements made therein. Apart from specific pleadings made therein with regard to defendant purchasing the trademark Sadanand from defendant number 1, hence the advance booking scheme made by defendant, finally sale of the rights of Sadanand by defendant to the defendant number 2 on 23/9/2020. The plaintiff also pleaded continuing cause of action is an alleged infringement of the trademark by the defendant numbers 1 and 2. So this was also the argued, like here without continuing cause of action. The nature of the suit filed by the respondent plaintiff presupposes urgency. Intellectual property rights are the right given to a person to creation of the minds of the intellectual to encompasses the trademark, trade dress, copyright, designs of the trade secrets and other rights bearing insignia of the creator, proprietor of a trademark. The trade dress and other types of intangible properties. It is wide-ranging of the rights where the creator or inventor of a creative outputs the claim of ownership of the product brand, including the right to reap commercial benefits for the use of the products. The urgency of the court intervention arises when intangible nature of the property. Unlike the property in traditional sense, which can be protected from misappropriation by physical means, as posting guards for prevention of trespass in occupations one house, the proprietor of the trademark can do little to prevent misuse of the trademark of sale. Otherwise, the proprietor obtains an order of injunction from a competent court. Further misappropriation of the intellectual property leads to immediate injury of the proprietor creator, including the loss of financial loss. Unlike the form of the property where the wrong appropriate can be quantified, infringement of the IPR is often unqualifiable as a wrongdoer rides on the goodwill of the mark brand. Therefore, time is always the essence. Even a single consumption of the mark by an unauthorized user can result in immense suitable injury to the owner of the product. For instance, a TV commercial using a trademark, trade name, rival products get-up reveals the viewing of the broadcast which should dilute the brand of the trademark or create confusion in the mind of the source. The respondent plaintiff could not be diverted to pre-institution mediation. The present case involves alleged misuse by the defendant's trademark such and such by the defendant by purchase of the rights of the trademark and also advance booking floated by the defendant number 1 allegedly by the plaintiff's trademark. The allegation of the misuse shows that the basis of urgency which imbues the cause of action of the suit. The nature of the suit, the cause of action release claim is a command urgency for the intervention of the court. The question is not whether plaintiff was entitled to protective orders of the court, but whether the suit contemplates urgent relief considering the pleadings and the plaint. There is little doubt that the plaintiff could afford the suit for could not afford to wait for pre-institution mediation, diverting the plaintiff. This remedy would have frustrated the suit. Otherwise, even the urgency which the plaintiff instituted the suit would also be evident from the plaintiff not losing any time before an application for interim injunction. It is not a case where the plaintiff went into hibernation after the suit, after filing of the suit and wake up from this timeline later fled for an interim injunction. Moreover, the plaintiff disclosure defendant Kohinoor has filed a suit in December 2022 against the plaintiff in Delhi High Court alleging infringement of the trademark and passing off claiming ownership of 3 trademarks. Presumably, the accelerated the momentum of the plaintiff to file the present suit against the defendant. The plaintiff also alleged the importance of the Kharif harvesting season for marketing products with the trademark in the southern states. Now, my lord, conclusion: we have no hesitation in holding. Justice Senator Barkore taka soft copy ta ontoto. We have no intention in holding that the suit instituted by the plaintiff for infringement of a trademark and passing off is wholly unsuited for pre-institutional mediation, since it contemplates interim leaves. We have considered the nature of the suit, the allegation made in the plaint, the cause of action pleaded, and the relief claimed by the plaintiff in COS number. The plaintiff Veda therefore cannot be held back for first to exhaust the remedy of mediation before institution of the suit in the pretext of Section 12A of the Act. The trial court correctly considered the plaintiff's cause of action and the defendant's alleged infringement activities and the suit filed by the defendant in the Delhi High Court to arrive at the conclusion the plaintiff was not required to comply with 12A of the Commercial Code Act before institution of the suit. The trial court found the plaintiff made out a case of waiving the mandate under 12A of the Commercial Code Act, accordingly rejected the and Miller, the revision application was dismissed. Now, Miller, Lordship will find here the other Miller division bench of Delhi High Court is quoted in this judgment in between the same parties. Lordship will, this is 2022 SCC online, Delhi 4455. देखिए फुलवाल ना दी. I might endeavor to show it, Millard, that even Millard, considering a 12A dispensation case, the court is considering the packets in question. That Lordship will find, Millard, paragraph 4, that's recorded in the order. That's recorded in paragraph, Millard, page 4, Millard, of Millard, the judgment. The packets are identical. Our packets are Soroshichke dao onto the eta par kore. Eight. So, Millard, court is prima facie, Millard, looking, Millard. What is the defendant doing? What is the stand of the defendant? And Millard, whether Millard it's a discretion when one of the courts is Millard doing Millard, that should be revoked or not. Kindly look at the 2 packets in question. This is Millard. This is them.
What is this?
Yes, this has to be done, Millard. The subject
What is
matter,
this?
This is the hose pipes.
Hose pipes.
This is them, and this is mine. This is mine. Pankaj, he is also Polypankaj. Poly small, Pankaj, same thing, same package, same get up, same product.
Just hold the 2 side by side.
Side by side. I'm type at the I lose everything, Miller. Then I have to borrow from my learned friend. This is Pankaj, this is Polypankaj. Same to same. This is why Millard I got a nod. And Millard Umid se jada mazbuti ke wada, and Millard other is mazbuti ke jada umid se wada. One is Pankaj, one is Poly. This is the Millard. This is the test, Millard. That's the reason I showed Veda, Millard.
But first of all, my lord, this is not our product.
What is
never
his
said-
product?
Shall
Yes,
show
never
from his
said.
pleadings.
Yes. This is
They shall
polypongos
show
and
from his pleadings.
yes,
He
yes.
is going now outside his pleading.
No, I am not at all,
Let
my
him
lord.
show where this is in his
Yes,
plain.
this is ponkos, this is polypongos. Same to same carbon cup.
Let him finish. I'll wait.
If this is not his product, Miller, the judge would have injuncted it. He is not agreeing. Now he is saying, look, this is part of the colored plaintiff copy guno bar koro, sob lagano ache.
You have in the pleadings, you have
Yes,
annexed
yes, I'm going
photographs.
through that, Miller. Now I am the judgment.
No, no.
Now,
You have annexed photographs in the
yes,
pleadings.
absolutely. Absolutely. Miller, I'll show.
Yeah, we are not going to retain those hose pipes with us.
No, absolutely not. Why, Miller? Colored copy Judge Sahib ke diyechen. Now kindly have a look at, I am very sorry, Miller. Justice Strength, Miller. It's photocopy, Miller. It's coming, Miller.
Justice Sen's judgment's photocopy is coming.
Yes, Miller.
We are
Justice
getting
Sen's judgment. We're getting that. কোথায় আছে দেখো তো আমার এখানে দুটো কপি লাগবে তো জজ সাহেব তো দুজন পাঠিয়ে দাও আমাকে জাস্ট মিলার আই শো ইট ফ্রম দি মিলার সফট কপি এন্ড আই দেন হেড অফ কোর্ট বুঝাচ্ছি দাও Miller, this was I argued and I lost Miller. So Miller, there are two views now in Miller. Kindly have a look at. Just Miller, very short order. This was also Miller. প্লেনটি কোথায় আছে বার করো that I show Miller and I give a printout. হারালে এটা তো ছিল আমাদের কাছে
এই দুটো এক্সিবিট এ এন্ড বি মার্ক করে রেখে দেবে ট্যাবলেট দুটো
kindly Miller takes very short order. This appeal is arising out of an order passed by the learned single judge on 2nd August 2023 পাঠিয়ে দাও না WhatsApp করে revoking the leave under 12A of the Commercial Code Act 2015. The reasons for revoking the leave was that initially the plaintiff issued a cease and desist notice on Miller 25th May 2021, pleading in the claim, and did not pursue the said claim. And thereafter, the plaintiff filed in the year 2023 the word recently used in order to show that in any event notice is served, the plaintiff will suffer irreparable injury. So this is the falsity. Miller, 2021 is the knowledge. You come in 2023, though it's pleaded in the plaintiff, you say it's recent. So it's masking Miller the cause of action. In the plaintiff, in the first place, plaintiff could have shown urgency in May 2021 and claimed dispensation of 12A, where it was clear infringement of the plaintiff is the registered owner of the mark. Usually, in a suit for infringement, ex parte order is passed on the principle that prejudice may be caused to the plaintiff in the event notice is being served. However, having regard to the amendment in the Commercial Code Act, it's discretion of the court as to whether the case made out for dispensation under 12A is held to be mandatory. In partial automation, it has been held, it has been noticed the tendency to bypass the section, it should be stopped, otherwise the section may be rendered ocious. The court is required to find out whether the averments in the plaint point out to the situation even before expiry of 3 months, the plaintiff may need to obtain urgent relief. In the facts of the case, it appears that from the impugned order, the plaintiff did not proceed with the matter and thereafter cease and desist notice was issued on 25th May 2021. Only thereafter on 26th April 2020, further cease and desist notice to create urgency in the matter. There is no pleading that after the earlier cease and desist notice, defendant has withdrawn the said alleged infringing material. The fact that the learned judge have taken into consideration directing the parties to file a fresh suit if pre-suit mediation fails, we are not inclined to interfere with the order in question. And my lord, this was my lord, which my lord the court held. So my lord, lordship says first notice 2021, my lord thereafter second notice 2023, and my lord filed in 2023 after
It is the
my lord, may I have? in fact, my lord, unit 10 है जो unique one, unique to the kindly, my lord, have a look at my lord the honorable single judge's two judgments, my lord, one before this, one after. And now see lordship. আগে unique টা এটা গোল কোথায় গেছে কেন?
Justice Mukherjee's division bench is earlier in time.
My lord, I just check up. I think this is early. এই যেটা দেখালে ওটা কবে Justice Mukherjee's Gravrial division bench is earlier in time. Gravrial division bench, Srishti, thereafter Gravrial division bench, SRMB, then Srishti. Srishti follows Gravrial.
Yes.
So, my lord, Gravrial, my lord, I had pointed out from the judgments itself. I am silent. If lordship wants formally, I can give formal. It's not necessary. Now, my lord, lordship will kindly take, my lord, honorable single judges judgment, my lord, prior to this and after this. Same principle, my lord. If this is up in appeal before your lordship, my lord, kindly have a look at unique, my lord. দাও জজ সাহেবকে দিয়ে দাও, ওকে কপি দিয়ে দাও আদার সাইড। দিয়েছো? কাকে দিয়ে? জজ সাহেবকে দিয়েছি তো, সৌমুকে দিলাম একটা কপি। কাইন্ডলি মিলার হ্যাভ আ লুক অ্যাট kindly take paragraph 10. 10. In view of the above, there is little scope for the court to examine the grounds of revocation of dispensation with the requirement of pre-suit mediation and settlement. Section 12A of the Act is imperative, and the suit which is to be instituted without following the mandate of the Act is to be rejected. The next, Millard, para 10 Millard, just Millard, the last few lines of Millard para 10, ending in page 5. The narrow compass in Jamini Monor, which has been left open, are the cases where the plaintiff seeks to artificially or falsely create an urgency to circumvent the mediation settlement in case where the request for urgency relief as pleaded in the plaint is not tainted or artificially. Ordinarily, the court must defer to the perception of the plaintiff the need for urgency. Millard, kindly check, Millard. There cannot be any deception, falsehood, or suppression in the pleading of urgency in order to obtain dispensation under Section 12A of the Act. So this is the learned single judge's own Millard judgment prior to this, which is up in appeal, Millard, before the court. Unless there is deception, falsity, etc., you cannot. So lordship has to test it, Millard, whether there is a falsity or a suppression by the plaintiff in question. Now, Millard, kindly takes Millard para 13. In such circumstances, the assertion in the plaint of the plaintiff having come to learn of the impugned product in May 2024 is patently false. So there was a false statement because the parties were before the trade fair from May 2018. Kishan Bikash Malay or something like. A party litigant cannot be indifferent and negligent in its duty to place all relevant documents and materials in support of the contention and is bound to produce the same. No one who comes to court must come with clean hands. Non-mentioning and non-production of true and correct information pertaining to Kishan Mela or WhatsApp messages and the documents in support thereof tantamounts to material suppression and in any effect playing fraud on court. So this is Millard what he's weighing. He said that you cannot withhold documents. You explain the documents in the plain. Para 14. Both the above facts are material and German on the aspect of knowledge of the impugned mark and suppression thereof can only be with the aim of wriggling out of the mandatory requirements under section 12A of the Act. Concealment of material fact disqualifies any litigant from obtaining relief. In the bargain, the plaintiff has deprived themselves of an opportunity of providing any explanation or justification, whether believable or not, either in the plaint or the court. That you have suppressed material, it's a concealment, and you try to get a dispensation. Now, let kindly, Millard, paragraph 17 is most important, Millard. This is he finds. Because my argument was relying on SRMB that if you could have waited for 3 months or more than 3 months, mediation period under the Act is 3 months, you could have very well done mediation and come to court. That is negated by the Honorable Single Judge, paragraph 17 in the other matter. The ground that the plaintiff has waited for 5 months before filing the suit, here it's Millard 8 months. And the fact per se disentitles the plaintiffs to seek dispensation under 12 of the Act is untenable and is rejected. Millard, if this is rejected, Millard, then Millard, my plaint cannot be rejected. If this is the proposition of law, because my argument basis on SRMB, which is quoted there, has been rejected on a recurring cause of action, then Millard, how Millard this plaint can be rejected without there being any falsity and deception. So Millard, the same Millard, there cannot be Millard two proposition of law on the Millard more or less similar set of facts. Because this was Millard the argument where there exists need for urgent relief or not is to be required from the totality of the circumstances. There must be a holistic approach. The fact that merely a time gap between the knowledge of infringement of rights or breach of obligation and the institution of the suit is only the parameter which determines whether the suit contemplates urgent interim relief or not. In such circumstances, various factors come into play, including relative position of the parties, subsequent events which have transpired during the interim, and the conduct of the parties. A finding cannot necessarily be based on the interval or time gap between the knowledge of infringement and the institution of the suit. This cannot be decided in isolation. Learned Single Judge Millard, I'll just show Millard, he says the plaint is a copy-paste plaint. And there's a recurring cause of action by itself is not a ground for waiving urgency. A, this is contrary, Millard, to Jamini Monohar. B, Millard, it's contrary to Vedas deeds. 3, it's contrary to Shrishti, Millard. And in fact, Millard, the subsequent judgment, Millard, I'm quite surprised. I had an occasion to part argue that the Nosil, the case of Nosil, Millard, where Millard knowledge may, suit filed in October, we have not been. Kindly look at me. John, copy though. It's a breach of confidential information case. And Millard, there was no interim relief in that suit. It's a subsequent judgment of 15th of May 2015. Lordship will kindly have a look at internal page 7. As Lordship found, just Millard, quotation Millard beneath Jamini Monohar. তিনটে ডেট দেখো গ্র্যাভিয়াল কবে এই কবে তিনটে ডেট লেখো সৃষ্টি on a holistic reading of the plaint in view of the averments made therein, in particular paragraph 26 and 29 of the plaint, it would be evident that the plaintiff has been constantly seeking information and making discrete inquiries at the apprehension and thus waited for some time. The timeless events, the timelines of the events and the facts totally broadly explained and justified in the plaint as to the urgency. The limited window which has been left open in Jamini Manohar is only deception, suppression, falsely creating urgency in seeking dispensation of section 12A of the Act. On a combined reading of the averments in the plaint and supporting facts, it cannot be said that there are no grounds of urgency pleaded which with contemplate urgency. The length of delay or interval or gap cannot be considered in isolation, unique quoted. In such circumstances, there is no deception or falsehood or suppression. The plaintiff, being dominus litis, is the best position to decide whether there is urgency or not in filing the suit. It's a subsequent judgment. It's on the plaintiff, he is to decide urgency. This does not involve microscopic examination on the aspect of urgency. Reopening of the question whether or not dispensation was rightly granted or not cannot become a weapon in the hands of every defendant in distress. Next. The exercise at this stage which a court undertakes does not require a forensic analysis of the plaint or supporting facts fully to justify each day's delay. As evident from a holistic reading of the plaint, timeline, sequence of the event, the plaintiff has sufficiently pleaded the requirement of urgency. I could have very well, my lord, the plaintiff could have said the goods went out of the market, the goods came back. And I would have filed a suit.
Yes.
So, my lord, first, unique, that my lord, time gap itself doesn't matter. Second, my lord, nocil, my lord, also the same proposition, my lord. Now, my lord, kindly let us, my lord, to show the papers. Ar kichu dekhano nei to.
Yes, now try to wind up slowly, Mr. Ghosh.
Yes, I'm winding up, my lord. I'm asking. Plainted ওই ছবিগুলো দেখাও আর গ্রাউন্ডসটা দেখিয়ে দাও। না, not necessary. Single bench গুলো দেখিয়ে কি করবে? দেখা যাচ্ছে জজ সাহেবের কপিতে। Lordship has, I am told, my lord, Lordship's brief has a colored copy. No. Kindly have a look at page 309, my lord, of your Lordship's brief. Lordship will, I believe, Lordship, as plaint is, injunction application is annexed, my lord. Plaint was annexed without, my lord. Kindly take the injunction application, my lord.
Page 309, paper book.
09 of the paper book. Annexure N. Plaint লাগানো আছে। Plaint আবার plaintও তো লাগানো আছে।
This is whose product?
This is my product. আমার তো। Pankaj Flex is mine. This is exactly shown to your lordship. My learned friend says this is not his product. Well, this is on English and Bengali Pankaj. Next 3010. Then my lord Pankaj Flex is mine. Then Pankaj. Then lordship will kindly take.
No, 3010 is whose?
My product.
Pankaj.
Flex delivery host. Miller 30, that's Pankaj, which is in Bengali. This is a side view of Miller, the host Miller I have just now given. Miller, page 311 is also the side view. 312 is also my side view. 313 is my learned friend's product. He said, Miller, this is not his product. And quite some authority he said so. Yes. Yes. Has he denied in his injunction application? This is not his product. Break a bolo. Kindly look, my lord. 313 Pankaj delivery pipes. 313 is the defendant's product. Then Poly Pankaj 314. Poly has become small. Same. Poly Pankaj. Kindly now take, my lord, page 315. My lord, Pankaj. Pankaj is written in Hindi, but in Bengali it's Poly Pankaj. Pankaj, Bengali. 316 is also, this is my product. So, my lord, 313 to 315 is my learned friend's product. This is what I gave in court.
317.
317 is Pankaj Flex. This is mine.
No. Poly Pankaj.
Poly Pankaj is 317.
That's what I'm saying. 317.
317. Lordship is absolutely correct. Have they dealt with it? বলেছে আমার product not. Vacating এ লিখেছে কিনা দেখো, দেখো। ওর product not. So, my lord, this is where it stands. Now, my lord, two things I'll say. My lord, this matter, my lord, got over, my lord, on 28th of, my lord, 22nd of February. Injunction was continuing. My lord, now, my lord, my junior mentioned, because the judgment was to be, my lord, delivered on 6th of May to extend it. The Honorable Single Judge has said that he will not, my lord, extend it, because, my lord, he feels, my lord, the court had been misled in passing, my lord, the order in question. My lord, and my juniors mentioned that point I have taken in the memo. That's neither here nor there.
After disposal of the matter you mentioned.
No. After the judgment was concluded, the hearing was concluded, judgment was not pronounced. The judgment was, my lord, pronounced on 6th of May.
Yes.
The interim order was till 30th of April. My lord, my junior, my lord, Mr. Dasgupta mentioned, Mr. Mukherjee mentioned,
Right.
the Honorable Single Judge, my lord, said, my lord, no. And so far my notes are concerned, the point I have taken, my notes were prepared. My notes, many judgments are there in the notes, my lord, at the time of, naturally, there's a
You are
garage
now
door.
asking for an interim order from us.
Yes, I'm asking for an interim order.
We are disposing of the appeal, Mr. Ghosh.
I'm not, my lord.
Don't
These
press
are my
that. Yes.
these are my one, my lord, one thing, my lord, I missed, my lord, I should point out, my lord. I missed, my lord, I should just point out. If your lordship, my lord, have a look at ওই যেটা বলছে না non mentioning ওই document yes. Kindly have a look at page number 420.
What?
Of 420. I'm not sorry. বার করো status reportটা বার করো. Be quick. One of the arguments made, this is a false statement on knowledge, my lord, before the court. This is, my lord, the documents, part of the documents relied on the, my lord, plaint itself. Kindly have a look at page 420, serial number 40. So his case is that there is a knowledge from 3rd February 2023. Lordship will find, my lord, serial number 40. Has Lordship found out serial 40? My lord, status report dated 3rd February 29203. It's obvious a typographical mistake, because Lordship status report, which Lordship will find, there's a status report. That date Lordship will find now, একটু 614টা দিন তো 614.
What is this document?
This is, my lord, documents relied upon with the plaint.
I see.
There is a, my lord, statement regarding a status report. So my learned friend's case is, you have stated, so argument was that the status report is dated 3rd February 2023. So you have knowledge of my product in question. Now, first of all, my lord, 3rd February 2903. 29203 is the date. Now, if your lordship takes the status report relied upon on the plaint or part of the injunction, it's 611. Lordship, kindly have a look at it.
So they say that you had knowledge from February 23.
23 because this statement is made in Miller the documents in question. But what is the date in question? That's most important. In the petition, it's not there. It's an oral argument. Now, Miller, kindly take 611. The status report, which I annexed, Miller, to the documents is 24th of August 2024. And the date of application of a trademark is, Miller, 3rd February 2023. Date of the application. So, Miller, he has put the date of the application, Miller, by mistake. And this cannot be a ground. It's, Miller, apparent. It's, Miller, 3rd of February 2023. And it has been advertised, Miller, in the month of, Miller, May. So how does one get knowledge? One can get knowledge from the advertisement in Trademark Journal. And he has got registration. So, Miller, naturally, if I had knowledge, I would have opposed it. Because my user is from 1976. This is not a case made out in Miller the vacating application or Miller the revocation application. The date is date of application. In these circumstances, Miller, I'll be praying for setting aside of you.
Yes.
I hope my learned friend is concluded. Yes. Because, my lord, I would not want any interruption.
Oh, only
interim order. No. That's
I have, Miller, the dates, Miller. If Lordship wants, Lordship can take the dates in question.
What date?
Regarding Miller, Gabriel, Miller, the date, Miller, of the division making judgments, Lordship asked me. Miller, Gabriel, the division 25th August 20, and Miller, Srishti's 23rd August 2024, and Miller, SRMB 2nd December 2020. SRMB is subsequent. I just checked it up by my junior. These are my respects.
The lot has been said, but what your lordships have not been shown till now is, my lord, the memorandum of appeal and the stay application. My lord, a party, my lord, generally has to be confined to the case which has been made out before your lordships. Lord, kindly first take, my lord, the memorandum of appeal. I will take, this is of some significance in this matter. Because what has happened should not happen, and the law is also otherwise. Gives me a minute. I just.
Yes.
Let's, if your lordship has the memorandum of appeal.
Yes.
Well, at first, your lordship takes ground number 4. For that, even prior to the passing of the order impugned, the Honorable Single Judge has been pleased to verbally refuse to extend the interim order of injunction by refusing all of the appellant's attempts to mention the matter upon notice and have the order of injunction extended at least till the date of pronouncement of the impugned order, 6th May 2025, while on the other hand, permitting the respondent to mention the matter and supply additional case laws days after conclusion of the hearing in the matter and depriving the appellant with any opportunity to consider and rebut such case laws, thereby, in effect, also prejudging the appellant's case and erred in so doing. Well, it kindly takes, it doesn't stop there. Ground number 5. For that, the Honorable Single Judge has been pleased to make various recordings in the order impugned which are contrary to what had actually transpired during the course of hearing and erred in so doing. Then, my lords, kindly seize ground number 6. For that, the Honorable Single Judge inappropriately recorded that the appellant chose to surreptitiously include case laws. Then, my lord, it doesn't stop here, it gets better after that.
Just indicate the grounds.
Yes,
You don't have to.
Then, my lord, kindly takes ground number. My lord, kindly see is also ground number 28, 29, 30. Well, it's 33. Well, it kindly sees 33. I'm not reading out 33, but just see 33.
Yes.
Lord, I have said, my lord, I will not press the ground. My lord, record it.
He has not said he's not going to
Yes,
press all the
absolutely.
grounds.
I have said
All
senior
the
counsel
ground.
prayed his
It's all
pressing.
recorded.
Yes, recorded. I have said so.
Well, on
Lordship will say.
YouTube, it's recorded which
Yes.
ground he has said he's
Yes,
not
I'll
going to press.
33, 38. I have
Only
said so on
two.
the first stage.
Only two
I'll
grounds.
not. I'll not 38, 30. I have said so. What I said,
My
my lord,
learned friend can take his seat. He had
yes,
his chance. He will
kindly
not
look at.
interrupt right now.
Kindly, my lord, it's not a question of interruption. It's a question of proprietary. My lord, kindly, my lord, takes my lord 38 and 38. First day I move, I say, my lord, whatever may have happened, as a senior counsel, I can't take these points.
Now, my lord,
And I asked for exemption. My learned friends junior insisted,
Yes.
no, let it remain.
Yes,
Because
it
it
will
crosses
remain.
several stages.
Yes.
I said I don't want.
Then, my lord, kindly see is 34. My lord, and these same things are there on affidavit in the stay application by the client saying he has personal knowledge, who was not even present. Now, my lord, apart from this, now, first judgment about Supreme Court. 2007, 5 SCC 359. Now, my lord, I'm relying on 2007.
Mr. Ghosh, who has certified these grounds to be good and sufficient ground? Whose signature is Obijit De?
I'm not pressing that first day. I said this is not done.
So, my lord, everything is on record. What was said is, my junior has told me he did not want to press only 33 and 34, but the other grounds all remain. And anyway, stay application has it on oath by the client saying it's true to his knowledge. That means he was present in court, because that is the effect of an affidavit. My lord, that also I'll cite a judgment on that. My lord, I am relying on 2007 5 SCC 359. But kindly takes paragraph 4. But, if I may praise paragraph 4, my lord, if really there was no concession, the only course open to the appellants was to move the High Court in line with what has been said in State of Maharashtra versus Ramdas Srinivas Nayak, in Bhavnagar University versus Palitana's Sugar Mill Limited. The view in the said case was reiterated by observing that statements of fact as to what transpired at the hearing recorded in the judgment of the court are conclusive of the facts so stated, and no one can contradict such statements by affidavit or other evidence. If a party thinks that the happenings in the court have been wrongly recorded in a judgment, it is incumbent upon the party, while the matter is still fresh in the minds of the judges, to call the attention of the very judge who has made the record. That is the only way to have the record corrected. If no such step is taken, the matter must necessarily end there. It is not open to the appellants to contend before the court to the contrary. This is exactly what has been done before your lordships. Lot of allegations. No application was filed before the learned single judge. Now, my lords, what is more important is, my lords, judgments were indeed cited. included in the notes which were not cited. This is what transpired in the court.
Whose note?
My lord, my learned friend's note. My lord, lordship knows that in written notes, lot of judgments are put. Not all are cited. My lord, the correct course then would be to take back the written notes and, my lord, leave out those judgments which were not cited. That was not done. Now, my lords, coming back to the matter in question, my lord, this is a conduct of a party coming to your lordships asking for a relief. Now, my lords, let's go back to the Commercial Courts Act, which is the main point out here. Now, my lord, another small point which my learned friends taken, let me just get out of that point, my lord. He was seeking for interim orders in case where the suit itself is dismissed of. Now, my lord, Supreme Court has now passed an order saying that cannot be done. My lord, this is the judgment, very recent judgment of 2025, my lord, of 27th May 2025, my lord, of the Honorable Supreme Court addressing this very issue, so far as his prayer for interim relief is concerned. This was also a commercial suit, my lord, which was dismissed. Appeal preferred, interim order was sought for. Supreme Court said nothing doing. Suit has only been dismissed. Where is the question of any interim order? Paragraph 5. Small order, my lord, on the point.
Yes.
Now, my lord, coming back to the matter, my lord, what is the question out here is, my lord, first of all, my lord, a lot of submissions were made on merits, intellectual property, products are to be looked into. My lord, my respectful submission on a principle of law, my lord, is that, my lord, when 12-way leave is being considered, my lord, what is required to be seen is only the urgency. My lord, merits or demerits need not be looked into. And what my learned friend cited all the judgments, but did not cite the latest judgment of Justice Pardiwala, my lord, with 12-way, which reaffirms, my lord, all these views that it is not the plaintiff's discretion any longer. My lord, Justice Pardiwala delivered a judgment, my lord, on 15th May 2025 in Dhanbad Fuels. My lord, I'll show that, my lord. He knew this, but he hasn't cited it, but I will cite it. Now, my lords, that takes care of all these judgments of our High Court, everything, my lord. Now the law is very well settled on this. Now, my lord, first and foremost, my lord, an argument has been made before your lordship that, look, that this suit, my lord, first of all, it's not an infringement action. First, my lord, I see a lot of, my lord, cases were cited with regard to trademark infringement. My lord, this is a case of passing off, because both are registered.
Yes.
My lord, Section 28(3) of the Trademarks Act clearly says that if two marks are registered, then there cannot be a case of, my lord, infringement. It has to be a case of passing off. Both are registered.
They have not applied for rectification.
They have applied, my lord, in January. That is, my lord, the cases. My lord, there is an averment, my lord, in a commercial suit that they have taken a printout of a status report dated 3rd February. Matlab, English is very clear, language is very clear, no question of maneuvering and saying, oh, it was a typographical error. They say status report dated 3rd February.
Which year?
2023. My lord, if they would have taken out a status report on 3rd February 2023, they would have seen that we have already applied for registration. All this while, my learned friend, nobody gets to know that is not correct, that till the mark is advertised. My lord, trademark registry maintains a portal. Any person can go to that portal and check whether any similar mark has been applied or not, which is open to every person. And they on oath say that it is a status, there is a status report dated 3rd February 2024. Fortunately, unfortunately, that status report has not seen the light of the day, but in the documents relied on, in a commercial suit, which is given that these are all true statements on my part, that document is missing. This is what I had pointed out from his own plaint. Now, dates are very important here. 3rd February, he says he has taken out a status report, according to his plaint. Then, my lord, he says 3rd December, of 2023, I have obtained registration. I have obtained, my lord, registration. I'll show the documents. Then, my lord, 4th January, he says everything happened on 4th January. He got to know that I have goods in the market on 4th January. I have flooded the market on 4th January. I have been selling goods from 4th January and I have already flooded the market. Then he says he has filed a rectification, which is also dated 4th January. One day wonder. Everything happens in one day. 4th January.
When did he file the suit?
September. 13th September. What is more important is, what my learned friend didn't tell your lordship, is he files the suit in September, moves the injunction application on 1st of October ex parte. Well, the party is, he has already filed a rectification, so he knows who I am. I'm not a fly-by-night operator because I already have a registration. And he is also contesting that. So he knows that I am there. He did not choose to serve before the vacation, my lord. He goes. Now, my lord, what has not been shown to your lordship is, has he, my lord, I put it in question form. The order granting 12-day leave has not been shown to your lordship. My lord, 20th September. At least, my lord, that is what I get from the record. My lord, that order somehow is not available.
Not available?
No. Let them show that order of 20th September.
My lord, leave was granted, my lord. The order was not served, my lord. What can, my lord, a litigant question? Plaint, in the plaint, my lord, the honorable judge has given a fiat.
Let us
ask for the production.
Yes.
Ask for the production.
No, this is of fundamental importance, Mr. Ghosh.
Yes, absolutely. I also ask, my lord. Let him argue if that is what he is following, my lord, the practice, my lord, the honorable single judge at that point of time.
Next din Anina. So would you wait till the records come?
The lordship will have a look at it because I know.
I also have taken it.
My lord, my learned friend will kindly now. He did not point this out. Now, my lord, he can reply, my lord, later on.
This is what my advocate on record has taken out, my lord, in his hand.
Sit.
So, my lord, we'll see the order, whatever order is there, if there is an endorsement, whether there is any application of mind, my lord, to the granting of 12A. Because the point taken, my lord, is the most unique point by my learned friend, that a court, once it has granted, say, clause 12 leave or 12A leave, that court, my lord, once it is granted, it cannot no longer be revoked. But I have not heard something like this ever in my original side practice. That because a court has granted clause 12 leave, subsequently the leave cannot be revoked by that judge. Or it has to go back only before that judge which granted leave. Very novel proposition.
I have not said so.
So, my lord, this is what was argued.
I have not.
And it was said so. And here also, your lordship, the grounds which I have indicated, my lord, they also say so in the memorandum of appeal. Because one single judge has granted it, therefore, other single judge should not have done so, referred it to a larger bench. This is all in this context. This is all in this context. So, my lord, 12-way leave, my lord, a court grows, my lord, somebody goes and asks for a clause 12, my lord, for example, a clause 12 leave. My lord, seldom, my lord, leave is granted. Then, my lord, what happens is the other side comes. If the other side can satisfy, my lord, that clause 12 should not have been granted. Any court, my lord, whichever court has the determination can always revoke the leave. My lord, there is no two ways about it. And my lord, this was what was argued. Now, my lord, next, which is of even more significance, my lord, trademark dispute and recurring cause of action. My lord, I've been hearing this for a long time. Now, my lord, the Trademarks Act, my lord, its first is 1940, then, my lord, 58, then 99. My lord, last is, my lord, what we have at present is the 99 Act. My learned friend says, Trademark Act gives me I can get an order at any point of time, there is an urgency, etc. But, my lord, what is very important is the Commercial Courts Act came in the year 2015 for a specific purpose. Now, my lords, when the legislature has framed, my lord, rules or, my lord, a statute, my lord, we have to, my lord, the presumption is it is aware as to what laws are already in existence. Now, let's go to 2(1)(c), which is with regard to commercial dispute. I know. Just sit down. So, my lord, sees 2(1)(17), 1C(17) is with intellectual property rights relating to registered and unregistered trademarks, copyright, patent, design, domain names, geographical indications, and semiconductor integrated circuits. And, my lord, the other different types of commercial disputes are made. So, my lord, if the Trademark Act, my lord, had created certain exceptions, my lord, and the Commercial Court Act thought, my lord, that exception should continue, then it wouldn't have said, my lord, that in case of 12(a), my lord, intellectual property should be excluded. The urgency required under 12(a), because what my learned friend's case is that because it is a recurring cause of action, my lord, I can come after 10 months, I can come after 15 months, I can even come after 5 years. Because, my lord, it's a law that every cause of action gives rise to every infringement gives rise to a fresh cause of action. So, therefore, in intellectual property, my lord, section 12(a) would be rendered OSHIO if I go take my learned friend's submission. Because, my lord, every time there is an infringement, I will say, therefore, so, my lord, first day, my right to sue when it accrues loses all its significance according to my learned friends. My lord, I may sit tight, do nothing, and because it's an intellectual property matter, I can come after 10 years also and say, look, this is an intellectual property matter, I have a right, I can move the court. My lord, when the language of 12(a) is also very important. This falsity, my lord, which is being said, this is falsity of the urgency. Not falsity of other things also. It's a falsity of urgency, which is very important. Because then in any intellectual property matter, any litigant can come before your lordship and say that this is an intellectual property dispute.
One second. Mr. Mitro, sorry, we didn't notice you have been waiting. We will rise at 12:15 and then 12:30 we have a larger bench. Very well. Very well. Yes.
So, my lord, in this case, my lord, the facts just keeps two dates in mind. His last, whatever he has awarded in the plaint is 4th January, when he says that I have flooded the market. And he files the suit on 20th September. Hiatus of 10 months. This plays enormous significance in my respectful submission because there is no explanation whatsoever in the plaint with regard to that.
20th of September.
Yes. 20th September, my lord, filed on 15th or 13th September.
13th.
Exact date is 13th September.
Filed on 10th of September.
10th, very well.
That is the affirmation. My lord, your lordship's online status from the case details shows 13th September. Mr. Ghosh may have a different online status.
Yes.
He may have a different status, but at least website. Very well, my lord. Anyways, my lord, whether it's 1st September, 13th September doesn't make any difference. But the fact is this hiatus. Now, my lord, it's 12A. My lord, matter has been argued, but 12A has not been placed before your lordship. My lord, kindly see it's 12A. Because, my lord, and another argument was made right at the beginning that Section 9 gives me an inherent right to file a suit. This was the very first submission, opening submission of Mr. Ghosh. That I have a right, inherent right to file a suit. But with the greatest of respect, no. Because of 12A. Because of the amendment. The 12A says, pre-institution, mediation and settlement. A suit which does not contemplate any urgent interim relief under this Act shall not be instituted. Shall not be instituted unless the plaintiff exhausts the remedy of pre-institution mediation in accordance with such manner and procedure as may be prescribed by the rules made by the central government. Then, my lord, 2, my lord, I'm skipping. Then, my lord, 3 is also, my lord, may not be, no, 3 is very relevant. 3, notwithstanding anything contained in the Legal Services Authorities Act 1987, the authority authorized by the central government under subsection 2 shall complete the process of mediation within a period of 3 months from the date of application made by the plaintiff under subsection 1, provided that the period may be extended for the further period of 2 months with the consent of parties. So maximum 5-month window. Now a plaintiff who can wait for 10 months, that plaintiff, my lord, could have very well exercised this provision which is there. Now, my lord, what is very important is a submission which has been made which says that pre-institution mediation was not possible. My lord, the section is very clear and, my lord, plain, the language. It doesn't say that pre-institution mediation, whether it's possible or not, should be considered. The duty cast upon a plaintiff is to exhaust the remedy. My lord, when the language is clear and unambiguous, my lord, nothing else needs to be looked into. And my lord, this applies, my lord, with equal vigor to all intellectual property matters also, like any other commercial dispute. My lord, there is no separate species or genus of intellectual property which will not be covered by 12A. My lord, no exception has been carved out, which my learned friend is trying to carve out. Oh, it's an intellectual property matter. Therefore, in all matters, 12A is a matter of course. Had the legislature wanted that, my lord, that exception would have been there. Words cannot be added to a statute, my lord. Now, my lord, what is very important, lot of judgments have been shown to your lordship. My lord, first being, no, Dhanbad, I'll give you the latest. My lord, Justice I.P. Mukherjee's judgment, Justice Sen's judgment, my lord, that Justice Sen's judgment actually was cited by me, the trial court and the appeal court, and not by my learned friend. Now, my lord, first, my lord, initially 12A was happening, my lord. First case which actually, my lord, brought some sort of a change, my lord, was Patel Automation. 2022 10 SCC page 1. My lord, that judgment said no. It cannot be the plaintiff's sole prerogative to decide whether the urgency contemplated will be. My lord, court has a discretion to look into the dispute and say, my lord, look into the pleadings and say whether, my lord, leave should be granted or not. My lord, Patil automation came in where, because it was noticed, my lord, that in all commercial matters, parties were attempting to wriggle out of 12A by filing, my lord, an interim application, irrespective of whether there was any actual urgency or not. Therefore, my lord, Patil decided, my lord, that no, this has to stop. And therefore, that judgment came. Copy আছে? দুটো copy আছে? So, my lord, this was a compilation, my lord, filed by us before the Honorable First Court. My lord, what I'll do is, my lord, I'll make over duto copy. I'll just hand it. You have copies. You have copies. So, my lord, Patil automation made the departure. Now, my lords, coming to very important, what my learned friend did was, while citing, my lord, Justice Mukherjee's order.
Just also address the point that Mr. Ghosh urged, is that when the defendant goes back to the court after grant of leave under 12A and says that, look, please revoke the leave, there is no urgency, it is the obligation of the defendant to say that I am interested in mediation.
Well,
this is what he said.
Well, to address that, my lord, right away, that has been already answered by the Supreme Court in Dhanbad Fuels. My lord, I don't even need an application. My lord, now Supreme Court is saying court can suo moto. My lord, after granting, can revoke the leave.
Correct.
I don't need to say anything. That is Dhanbad Fuels, my lord, of Justice Pardiwala, which has not been cited before, your lord.
So that's the latest use.
It's the latest one.
Mr. Rajudri, today before you proceed, almost 12:15.
Very well.
We will rise because then the larger bench will come back at 12:30.
Very well.
When? এটা কি commercial তো কবে হবে? Let it run in the list.
Yes, ma'am.
Except Millard, Friday, there's a bereavement in the family.
Very well.
Because my sister-in-law has passed away.
এটা তো কোনটি? It will run in the list tomorrow. First is appellate side. After, if appellate side list is exhausted, then original non-commercial, then commercial.
Very well.
Hey, likho.
The only thing, if your lordship in the meanwhile can call for that, my lord, order.
We will.
Lordship will definitely call for.
The records, the trial court records will call for. Mr. Devnath Ghosh, learned senior counsel representing the appellant, concludes his opening submission. Paragraph, Mr. Shomura Chaudhuri, counsel representing the respondent, begins his argument but does not conclude. Paragraph lists this matter once again. Date diye do. Paragraph, on the next date, let the records of the learned single judge be produced before us.
Including the plaint, Lordship will say that the plaint.
The most important part of the record, Mr. Ghosh.
It doesn't come, Millard. I have faced it, Will.
Including the plaint, records, learned single judge, including the plaint. Eh?
Adjournment matter item 1 to 3.
Lord, I am appearing on behalf of the respondent in one matter. That is here LCP number 7 of 2025. That's item number 3. Contempt number 8, Mr. Kunal Ghosh.
Today, the alleged contemners were supposed to file affidavit answering the rule.
Yes, I have prepared. The affidavits are there, madam. এটা জজ সাহেব তিনটে কপি
Sir, please indicate which matter on behalf of which respondent you're filing, otherwise it will be difficult to record.
All the containers in all the three matters, 1, 2, and 3, 5, 6, and 7. I'm appearing for one could say Mr. Ghosh.
I am appearing
Mr. Ghosh, I'm appearing for the remaining all the containers.
is creating obstruction.
This is creating obstruction, huh?
I can't. And now I am all right. Now it is all right. My lord,
Obstruction in the administration of justice.
now I should not be deprived of to see this beautiful face of my lord, Mr. Justice Bhattacharya.
More importantly, the reactions.
Huh?
More importantly, the reactions.
Your lordship doesn't have any reaction. That's the whole problem. I can't understand in which whether you have taken my argument is accepted or not accepted.
Yes.
Not much reaction.
Presence has to be recorded.
Yes. My client,
Yes, of course.
Present. Mr.
All the contemners are present, your clients?
Yes.
Then do you wish to make any oral submission?
I have. But I have a preliminary objection about the maintainability of this proceeding, and with great respect to your lordship, my lord, taking up this matter by your lordship and to issue rule of contempt. According to my knowledge, my lords have no jurisdiction to issue rule of contempt. I will make first that submission. My second limb of submission is that let's assume that your lordships have the jurisdiction. The suo motu contempt proceeding is not maintainable. These are my submissions. Then third part, my lord, I will come to the merit.
Mr. Banerjee, could you please repeat the second point once?
Second
No
point,
jurisdiction?
let's assume that this court is having the jurisdiction. This bench is having the jurisdiction. Even then, this suo motu contempt proceeding in this manner is not maintainable. Not in compliance with the provisions of the section 15 of the Contempt of Courts Act. We have served with a rule of contempt issued by your lordships. We have served with the copies of the applications or affidavits. We have served with the orders of this Honorable Court. But we have not served with the order of the Honorable Chief Justice. But I have just for 2 minutes I have.
You want to see that order?
Lordships, kindly take this order first.
এই বেঞ্চটা যে কনস্টিটিউট করে চিফ জাস্টিস যেটা দিয়েছেন সেটা কোথায় আছে?
Bench is not.
What our understanding is, certain affidavits were placed before the Honorable the Chief Justice, who took suo motu cognizance.
What is suo motu?
Court on its own motion.
Oh, no, kindly see this. And own motion means what? I am coming to that one after another. But the entire order is not with me, Miller. Kindly just read with the order. Certain allegations as so and so have been made.
এক কপি আছে? The profile থাকবে। 20th April.
And if your lordships kindly give me the copy of the order, just I read it.
You read it.
Fine. Just
Either down again.
that will be, I think that will be very
Everybody.
for everyone.
Yes.
Let me read it, my lord. First. Lay before the Honorable the Chief Justice. The relates to CRS so and so filed with the leave of the Honorable the Chief Justice and Honorable Justice Choitali Bhattacharya on 28th April 2025. Both the affidavits are related to the acts of obstruction of justice, intimidation of advocates, scandalizing of the court, and interference with the administration of justice committed on 25th April 2025 at 10 Kiran Shankar Rai Road, Kolkata, so and hence praying for taking up the matters as suo motu proceedings for criminal contempt under the Contempt of Courts Act 1971. There were affidavits were there. Both the affidavits are filed against Raju Das, Shubhendu Das, and Atanu Rai by one Amitabh Ghosh and another by one Tapas Mehta. The matters are most humbly placed before a lordships for appropriate order. Therefore, who has written Samrat Gupta, officer on special duty, to the Honorable the Chief Justice, 28th April. Matter was placed before the Chief Justice. The matter was mentioned before the courtroom number 1 today, 28th April 2025, by several learned advocates who were informed in the submissions that the incidents which occurred on 25th April 2025 at Kiran Shankar Rai Road, Kolkata 7-1 is a clear interference to the administration of justice and a threat meted out to the judiciary and the learned members of the bar. Video clipping was shown to us in which it has seen that one person was stamping the photograph of Honorable Judge with his feet. The interview given to the concerned YouTube channel was translated and explained to the undersigned in English, from which it appears prima facie. Just the prima facie stamp is so and so. The interview was given to the concerned and explained to the undersigned in English, from which it appears from prima facie clear the person was mentioning about the names of the honorable judges present and past. There was also mention about orders passed by the Honorable Supreme Court and the names of the senior advocates were also taken. Thus, I am convinced, thus I am convinced that the matter requires immediate attention to protect the image of the judiciary from spurious and baseless allegations. Hence, I deem it appropriate to constitute the following special bench, comprising 1, the Honorable Justice Honorable Rijit Banerjee, 2, the Honorable Justice Subhoshachi Bhattacharya, and 3, the Honorable Justice Rajeshri Bhattacharya. Excuse me, kindly excuse me. Justice Bharat. The petitions along with note be placed before the Honorable Judge so as to enable the Honorable Special Bench can fix a date for the matter to be listed. 28th April, signed by T.V. Sivagnanam, Chief Justice. My Lord, before I start anything, I should have said first, I tender my unqualified apology to your Lordship's Court if I have committed any contempt. Then I am going. Before I start, I should have said first this. Therefore, now kindly see, Chief Justice in his administrative capacity has constituted a bench and send it to your bench to this in his administrative capacity. It was not a judicial order. Then this bench has been constituted to go into the sum and substance. Chief Justice has not said in an administrative order contempt proceeding is initiated or suo motu rule is issued. It cannot be done by a Chief Justice in an administrative capacity. It is not an initiation of a suo motu contempt proceeding by the Chief Justice. This part of the administrative order does not show that contempt proceeding has been initiated under Section 15 of the Contempt of Courts Act. A pure and simple administrative order by the Chief Justice, constituting the bench. Now, Your Lordship.
One second, sorry.
My Lord, kindly take this one. Mr. Sengupta is.
May I have a look at it?
Yes, yes, of course.
I said that I will give it.
Oh, I told him.
Otherwise, again, I may commit a contempt.
I have taken it from my lord, therefore.
Yes. Now, my Lord, kindly come. Kindly see the Calcutta High Court contempt rule or contempt of court rules 1975. I hope your lordships are having. And your lordships have considered all that rules and issued the rule of contempt. I hope so. It is not there. Calcutta High Court contempt of court rules.
No, नहीं है तो ये.
नहीं, I know नहीं.
अरे एस पाल साहेबेर বই কন্টেম্প্ট অফ কোর্টস অ্যাক্ট.
Otherwise, I can hand it over.
Give. If you have, why are you holding it back?
I am not holding it back. I was thinking, if it is everything is there, then I will not.
Then he will give a copy to me. That's why you.
No, পার্থদা সব জানে, পার্থদাকে রুল দিয়ে। Kindly come to the Calcutta High Court Contempt of Court Rules 1975, Rule so and so. Kindly come first to Rule 2. Proceeding in connection with the civil contempt may be initiated by a petition present so and so, it is not required for us. Or by the High Court on its own motion. High Court by its own motion. What is own motion? I'll explain later on, but I think this rule is sufficient for the first category of my submissions. On a reference made to the High Court by the subordinate court as the cause of criminal contempt, proceeding in connection with the criminal contempt may be initiated A, on a motion of the High Court in respect of a contempt committed upon its own view under Section 14 of the Act, not applicable, on its own motion by the High Court under Section 15 subsection of the Act, or C, on a motion founded on a petition presented by the Advocate General under Section 15(1)(a) of the Act, and D, on a motion founded on a petition presented by any other persons with the consent in writing of the Advocate General under Section 15(1)(b) of the Act, on a reference made to the High Courts by the subordinate courts under Section so and so. There are 3 or 4 categories that there. One of the category is that with the consent of the Advocate General. And second of the category is that court on its own motion. Contempt may be initiated on a motion. Administrative order does not reflect or cannot reflect initiation of any motion. Next. Every petition shall be expressed to be made in the special jurisdiction of this court, provided that every petition for civil contempt shall be expressed to be made in the special civil jurisdiction, and that every petition for criminal contempt in the special criminal jurisdiction. It is under the special criminal jurisdiction. Now, my lord, kindly come straightway Rule 16. It is all petitions presented by the Advocate General and all petitions presented by any other persons under Section 15 of the Act shall be moved before the bench presided over by the Chief Justice or by such other bench as the Chief Justice may from time to time appoint. All matters relating to contempt, subordinate court, brought under so and so shall be dealt with by the bench presided over by the Chief Justice or by such other bench as the Chief Justice may from time to time. On that date, when the administrative order was passed, it was not moved before the Chief Justice. Or any other bench determined by the Chief Justice, which is called the jurisdiction. Again, I read. All petitions presented by the advocate, all prescribed by any other person under Section 50 of the shall be moved before the bench presided over by the Chief Justice or by such other bench as the Chief Justice may from time to time appoint. All matters relating to contempt of so and so Chief Justice or some other bench as the Chief may from time to time. Next, rule issued by any court on its own motion shall be dealt with by the particular court, provided that such rules under Section 15 of the Act shall be heard and determined by such bench of judges as the Chief Justice may appoint. Rule issued by any court. Rule issued by any court on its own motion shall be dealt with by the particular court, provided that such rules under Section 15 of the Act shall be heard and determined by such bench of judges as the Chief Justice may appoint. 18. Notwithstanding anything contained in Rule 15 to 17 above, the Chief Justice may assign a rule. Chief Justice may assign a rule for hearing before another judge or bench if required in the special circumstances of the case, or if the judge or the bench reports to the Chief Justice for so doing. Therefore, when the Chief Justice can assign a rule. Chief Justice cannot assign a whole contempt matter to a court, contempt application. Only a rule, if the rule has been issued by the Chief Justice. No rule has been issued by the Chief Justice and thereafter it has been assigned to a lordship. And my lord, with great respect to your lordships, my lord, kindly do not take me amiss. For all arguments' sake, I will be arguing. Your lordships have no power to issue rule. If a rule has been issued and it has been assigned to your lordships can decide the matter. Therefore, when the rule was issued by your lordships, my lord, with great respect, your lordships did not have power. Maybe as a special bench.
So that's the first point.
We have to go by the rules.
Yes. So no power, no jurisdiction. Now, second point.
No rule has been issued by the Chief Justice at all. By a competent court as defined as settled by your lordship's court rules. Rule has been issued in this case by the assigned bench, which does not satisfy the requirements of Rule 15. This is my first one. This is my first
Yes, yes. We have noted.
Shall I proceed?
Yes.
Now, very importantly, your lordships kindly come. In re suo motu proceeding by Honorable Court number 1. Why is that suo motu proceeding? What do you mean by suo motu proceeding? When a rule has not been issued,
What are
order,
you-
kindly see your Lordship's order. Dated 2nd May 2025.
তাও যেটা বলছেন তাও
2nd May. Why is the proceeding? Tested before the bench. And on the first day it has come before the Lordship's court.
second May order.
In re suo motu proceeding by the Honorable Court number 1, what he has initiated. What is can the Chief Justice in his administrative side initiate a contempt proceeding?
We have 2 copies.
Where is that? And an administrative side and an order has been passed. It doesn't mean that a judicial court has initiated a suo motu proceeding. But we have seen that.
Yes.
Now see your Lordship's kindly address your Lordship's order. Mr. Jointo Mittu, Senior so and so, for the petitioners in CRLPP number 7 of 2025. Then your Lordship see so and so for the petitioners in CRLPC 6 of 2025. Therefore, after see Mr. Parthasarthi Senior so and so for the petitioners in CRLPC of 2025. Then again for the petitioners so and so for the alleged contemners. Therefore, before your Lordships, there are petitioners. If there are petitioners, how it can be a suo motu? If the petitioners are there, my lord, in that case, first is consent of the Advocate General is required to be taken.
Yes.
Now, your Lordships, can you read the order, paragraph 1? These proceedings for criminal contempt have been initiated suo motu by the court of the Honorable Chief Justice. What from your Lordship have got it? Not the court, but an administrative order. Then, Malaka, we have gone through the materials which have so far been brought on record, including affidavits of person, so and so. We are of the view that the criminal contempt has been committed in this case by the alleged contemnants by interfering with the due administration of justice, judiciary. Your Lordships have formed your Lordships' opinion of committed contempt. What trial, what argument I will make? It is not that prima facie your Lordships were satisfied, but your Lordships were satisfied. We are of the view.
Prima facie. Sentence starts with prima facie. Please read.
We have gone through the materials which have so far been brought on record. The affidavits who were present at the place of. We are of the view that the criminal person have been committed by the interfering with the due administration.
Prima facie. It's not there in your.
Oh yes, prima facie. Sorry, prima facie we are of the view.
Yes.
Hence, no notice be issued. Kindly come to next order. Again, in review of suo motu, so and so, court is on its motion, so and so.
Now, সবই নাও তুমি একবার করে দাও।
এটা তো।
Date of the order, next order?
Yes, the order is dated, my lord, 19 May 2025.
that আছে তো নিশ্চয়ই।
Of the Commissioner of Police be kept with the records. My lord, got it? A report filed on behalf of the Commissioner of Police be kept with the records. Affidavit filed on behalf of the Incorporated Law Society be also retained with the records. By our order dated May 2, we had ordered recorded the prima facie. We are satisfied the Commission of Criminal Contempt. We are granted liberty to the alleged contemners to file their replies within a fortnight from suancy. Today, all the alleged contemners are represented through learned advocate. None of them filed the affidavit. The allegations against them remain uncontroverted. There will be rule against the alleged contemners. The rules are made returnable on January 16. Therefore, rule have been issued by your lordships. With great respect, under our contempt rules, assigned bench has no jurisdiction to issue rule.
Just for our clarification,
Yes,
under rule কোথায় গেল রে বাবা? Under rule 16 doesn't talk of assignment of rule. 17 says rule, 18 says rule.
All petitions, let me read it. All petitions
Yes.
presented by the Advocate General and all petitions presented by any other persons under section 15 of shall be moved before the bench presided over by the Chief Justice or by such other bench as the Chief Justice may from time to time appoint. On the date it is alleged to be initiated. That date this bench was not existing. Let's assume Chief Justice on usual days, Chief Justice determination has been given to a bench presided over Justice Arijit Banerjee for the content matter. I can understand Justice Arijit Banerjee sitting with Honorable Justice Sukosachi Bhattacharya has taken up the matter. But on the day, determination was with the only Chief Justice. There was only the Chief Justice bench. Bench means court. Where is that order here?
Sir Banerjee with the
This one.
With the leave of Justice Banerjee. Now here, this Rule 2A, read with Rule 17, can't it be interpreted that there is a distinction between initiation of a contempt proceeding and issuance of a rule? Suppose even in contempt applications, an application is filed, that is the initiation of a contempt proceeding. Subsequently, prima facie being satisfied, we issue a rule. Now, we are speaking against you so that you can...
Yes, my lord, yes.
Now, let us contemplate it like this. 2B empowers the High Court to initiate a contempt proceedings. Proceedings in connection with a contempt, criminal contempt also, may be initiated by the High Court of its own motion. Rule 2.2. Proceedings in connection with a criminal contempt may be initiated on a motion of the High Court in respect of a contempt. Now, proceeding is initiated by the order of the Honorable Chief Justice, barring your administrative portion, will be coming to that. Proceeding is initiated by the Honorable High Court. Then under section 7, Rule 17, this bench issues a rule. So then Rule 17 says rules issued by any court of its own motion, proceedings initiated by the Chief Justice under 2.2 sent to us, constituted a bench, and then we issue the rule under Rule 17 and we will deal with that. Can't it be interpreted that Chief Justice only initiated the contempt proceedings, but the issue is, the rule is issued by us for the first time?
Let's take it. Who will initiate? A court?
Yes, Chief Justice's court.
Court?
Yes.
But here the court has not initiated.
Can't there be two components of the same order?
No.
Judicial and administrative?
No. Administrative order thoroughly, this is a different. Administrative order cannot be treated as a judicial order.
The first part is that suo motu proceedings has been initiated by the chief.
Why?
And the matter is the bench is assigned.
Madam, may I just,
Yes,
may I clear it? My understanding. Court means what? High court means what? If you say high court, then the high court enters all the judges. Or Chief Justice has made a determination. If you say high court, then high court all the judges have to sit and they issue the rule. Or the Chief Justice. Or determination given by the Chief Justice. Therefore, it is very clear it should be a judicial order. But that my argument will make it very clear when I read Rule 17. Assignment is after the issuance of the rule. Make a legal, and I am arguing actually against the judicial, against a person who may be your learned brother in a here, and who is practically my brother in other life.
That has got nothing
to do.
Absolutely.
But I am sorry. But,
No. We are on.
This 17 rule has not been assigned. But even if we give an effect interpretation of the Rule 2, the way my Lord Justice Bhattacharya is making the observation, then Rule 17 has to be ignored. A statute has to be read whole, not part. Second part, it will take time. Now it is 10 past 1.
Very well. Next Monday.
From 2 o'clock, I have matters.
Next Monday.
Give me some more time, not for half an hour.
No.
So that I can finish it. It is not
1 hour. 1 hour.
30 তারিখ হ্যাঁ 30 তারিখ কোনো অসুবিধা নেই
Yes.
তারিখ আমার অসুবিধা কি না আমি থাকবো না
Just
one request I will make, my lord. If your lordships can dispense with the appearance of the contempt.
Yes.
Before your lordships do that, but just for a digression, kindly look at the penultimate paragraph of your lordship's order. Which order?
Which order?
Our order or Chief Justice's order?
Your lordships. 12:30 a.m. they have been directed to appear.
They appeared.
At 12:30 a.m.
Oh, it's all right. Anyway,
Taking you from Mr. Bandyopadhyay's argument that it is there at 12:30 a.m. High Court doesn't see it. How can they appear?
Affidavits
I have not given
filed by the alleged contemners
mind to that extent.
in court today. Be kept with the
Normal
records.
court hour.
Stop. The personal appearance for the time of the alleged contemners is dispensed with for the timing upon their undertaking to be present as and when so directed. Paragraph, Mr. Bandyopadhyay, learned senior advocate representing the respondent number 8 in
CRLCP 7 of 25.
Yecho,
CRLCP 7 of
begins his argument. Stop. He does not conclude. Paragraph. List this matter once again on Shamne Sombare date the 30 tarikh. Marked 12:15
12. I will finish by 1:15.
ঠিক আছে, মাস
So that
12
we
noon.
finished it.
12 noon. ঠিক আছে. Yes, because after that we'll have to hear others.
I am not available every day. Do not want to.
We know how busy you are, Mr.
No, that different parts, different things. Tomorrow, interestingly, I will tell you, finish the order. Tomorrow I have a meeting of law standing committee and I'm leaving today after doing another matter. Agenda, do you know the agenda? You will be annoyed with me. Agenda is ethics of the High Court judges and the Supreme Court judges.
You alternatively create the law and then challenge it before the court.
That's a different thing. Second is no post retirement appointment. We will make it, you will strike it down. A proposal, discussion. Deeply obliged to your lordships. Deeply obliged.
Not come to court at 10:30. I was a minute late, my lord. With my lord's kind leave, may I mention only for drawing up and completion of an order, my lord. My lord does not scold me for mentioning out of turn. I stand for an apology. My lord, the decree was dated January 9, 2024. At that time, I was the advocate on record. On instructions of my client, I had immediately applied for drawing up and completion of the decree. But my lord, I'm deeply obliged, my lord.
Oriented commercial passover matter new application item number 1.
Lord, I am the appellant.
Not what had happened, my lord, I just in detail. First call, it was passed away. Second call, my lord, since your lordship.
There wasn't second call.
No, there was. This is the second.
This is the second.
I have a matter fixed at court room number 30. So I requested if the matter can be adjourned for the day.
Yes,
Then after that, my lord, what
I
had
won't
happened,
come
my
in
lord,
that.
I got a call from the other side that they are going to take an adjournment in 30th. So I have made myself.
But anyway, my lord, let it retain its position and remain on Wednesday. I think your lordship takes up, my lord, commercial and non-commercial matters from the original.
Very well.
date on Wednesday.
Very well. On the request made jointly by learned advocates for the parties, comma, let this matter stand adjourned and be listed again on Porshudini data, the other, comma, retaining its position.
Grateful. It was my mistake.
No, it was. We are both, my lord, on the same side. So we always, my lord, grateful.
That was my mistake, my lord.
No problem.
Passover matter item number 8.
I beg to appear for the appellant, my lord.
I know Mr. Mitra was waiting entire morning.
I'm told he's on his way, but
He'll
my lord,
come. He'll do the matter.
that's what I.
Who's on your other side?
They were here in the morning. Hey, James. He's the advocate on record, my lord. For BLA.
We'll wait for him. If he's coming to this court, you know that.
My lord, that's what I've been told. That's what I've been told.
We'll wait for him. No problem.
Wait for me.
ঠিক তো নেই কিছু। যাও দেখো টু ইমেজিন টেনশন গুলো আছে, যাও দেখো করো। হ্যাঁ, পাস ওভার করে, হ্যাঁ চলো।
অন করে রাখা 1 2 1 2 1 and 2. Non-commercial item number 1 and 2. My notes of argument is ready, my lord.
Don't.
Yes, my written notes, my lord.
They have already filed, no?
Last occasion, possibly, my lord, they have bring, my lord, whether he has filed or not, my lord, I do not know, my lord.
You filed?
Yes, my lord.
Other, you are for Molina Day?
No, my lord.
No, they are for Molina.
They are for
এই অ্যাপেলেন্টের কোনো রিটেন নোট আছে দেখো তো।
my lord,
ওই যে
he is
আসছে।
he is coming. He is coming.
They are filing their written notes of
We are
argument.
also filing it, my lord. Just, my lord, I will take 1 minute. This is with my advocate on record. It's coming, my lord. It's all ready, man. I was sitting.
There. Written notes লিখে নাও। Written notes of arguments filed on behalf of the parties be.
ঠিক আমি দিলাম তো দেখুন তো।
This bench heard, na?
Yes, my lord.
Be kept with the records. Paragraph. Reserve করে দিয়ে কি
Yes, sir, reserve.
Hearing is concluded. Stop. Judgment is reserved.
Great.
New application item number 3. Please, your lordship.
May it please. Well, this is an application for recalling your lordship's order, my lord, dated 28th of April 2025, my lord. I've annexed it, wherein, my lord, your lordship was pleased to dismiss the appeal on the ground that no one had appeared. My lord, the matter had appeared, my lord, once before in the warning list. My lord, the explanation has been given as to why the advocate concerned was not present before my
You're
lord.
appearing. Restoration, Mr. Dutt will never oppose.
My lord, 8 and 9 are the two paragraphs.
Very well. Anything remains in the appeal, Mr. Ghosh?
Yes, ma'am.
Appeal of 2014.
Yes, my lord, I understand. It
Likha
had
now.
appeared in the warning list. My lord, along with this, there are two other applications.
One by one, Mr. Ghosh, one
As
by
you
one. এটা লিখে নাও 3 নম্বরে যেটা জিএ আছে IAGA. This is an application for recall of an order dated April. This is an application for restoration of APO 335/2014, which was dismissed for default on April 28, 2025, along with the connected applications. Stop. Paragraph. Having heard learned counsel for the parties, we are satisfied with the explanation furnished for absence of learned advocate for the appellants on the day the matter was dismissed for default. Paragraph accordingly, the order dated April 28, 2025, is recalled. Stop. APO 335/2014 is restored to its original file and number along with the connected applications being GA4 of 2023 and GA5 of 2023. Paragraph. GA6 of 2025 stands disposed of. Paragraph lists the appeal 2 weeks hence.
My lord, prior to the enlistment of the appeal, may the two applications come. I'll tell your lordship, this is, my lord, an appeal from an order. My lord.
Very well. List the appeal along with the applications when?
My lord, 1 week hence.
1 week hence, bracketed Tariq to the other.
My lord, only one thing. My lord, the application is for substitution and another application is for conversion from an application for grant of probate to the application for letters of administration. So, my lord, until and unless these two applications are heard, the appeal cannot be proceeded with.
Appeal will anyway be listed.
Along with the applications,
Yes,
then we'll.
That's what we said.
We'll get them. My lord, may the affidavits of service be kept on.
Affidavit of service filed in court today be taken on record.
All the three applications are accordingly disposed of. My lord.
Yes. Oh,
Item number 4.
same. Four.
My lord, yes, the two applications, we had made separate applications for that.
Oh, I see.
As per the instruction of the
Oh,
department.
so first one was only for restoration of the appeal.
Appeal and
তাহলে শোনো প্রথমটায় খালি অ্যাপিলটা রেস্টোর করো along with connectedটা বলো না বুঝতে পেরেছো হ্যাঁ তারপরেরটা হচ্ছে ওই GA4টা রেস্টোর করো তারপরেরটাই GA5টা রেস্টোর করো
Item number 5. Item number 6.
Lordship, in this matter, the paper books have been filed with the department on the last Friday, Your Lordship.
Last Friday এই জন্য নো পেপারটা দেখাচ্ছি বোধহয় হ্যাঁ
Last Friday.
এসে গেছে
That's right. And Mr. Dhruva Ghosh is appearing for the state in this matter.
Mr. Dhruva Ghosh.
He is on the way, Lordship.
Way, but who's for the other side? Have you served, supplied copy?
There was the substituted service which was recorded in the last order because they are not available. That is also recorded in the order prior to the last order, Your Lordship. Not the message that I get to
Anyway, pass over then. He's not here.
Lordship, passes it out.
Item number 7.
We have concluded our arguments in appeal.
7 and 8.
Respondent was to argue. Anybody. We have also made an application. That is GA number 1, my lord. I was saying Your Lordship will pass order in terms of play because there's other side sought to execute the decree claiming 3 crore 16 lakhs. We have kept apart 3 crore 18 lakhs in a separate bank account. So they are fully secure.
Maybe passover, other side is not here. First call, Mr. Agarwal. Chalo, daku.
Item number 9. But I appear for the respondent.
I am led. This is the matter where Mr. Banerjee had argued on the point of order to Rule 2 on the basis of Srirampur property. Mr.
Is he in
Banerjee-
court?
Yes, I am been told that he is on legs. He can start because he was in reply. Your Lordship was has heard us and Your Lordship was hearing them. Lordship can he can
Whose
start.
appeal is this? Your appeal? No.
Yes,
So you have to give reply today.
Yes, to give reply.
Very well, start.
Right. Lord, as far as the point on order to Rule 2 is concerned, my Lord, I had concluded my submissions on that point, saying that the cause of action is one and the same. My Lord, there's another point in this appeal, my Lord, that the suit was also dismissed due to the fact that it was not instituted in the commercial division. Whereas, my Lord, there's a pleading in the plaint to that effect that the transaction is purely commercial in nature. I was addressing your Lordships on that point, my Lord. I shall continue on that. My Lord, if your Lordship kindly takes, my Lord, one paragraph, my Lord, I would like to show your Lordship, my Lord, page 15, para 30, volume 1, my Lord, of the paper book, just to show, my Lord, that there's an admission on the part of the appellant itself in their plaint that the transaction is purely commercial in nature.
Why they have claimed commercial rate of interest?
Yes, my Lord, they have claimed commercial rate of interest, my Lord, but at the same time,
This is what are you showing? The plaint?
the plaint.
Which paragraph of the plaint?
Para 30, page 15, my Lord.
30.
Yes, my Lord. Page 15, para 30. Lord, if I may read, my Lord, the plaintiff therefore seeks decree for a sum of 2.83 crores against the defendant number 1. The plaintiff is entitled to and claims further interest on and from 1st April 2022 at 18% per annum, full stop. The nature of the transaction between the parties is purely commercial. And the rate of interest is not only appropriate and proper, but also necessary to compensate the unjust benefit being enjoyed, my Lord. Hence, my Lord, they themselves say the transaction is purely commercial, and rightly so, my Lord, because the plaintiffs are real estate developers.
As a proposition of law, you tell us, Mr. Bose, if an absurd statement is made, we are not saying this is absurd, just to test the principle. Absurd statement is made by the plaintiff. Will that be binding on the court? If the court otherwise finds that this is not a commercial transaction, just because the plaintiff has said, will that be binding on anybody?
My Lord, I'll just indicate with regard to that, my Lord.
This may well be a commercial cause. We are not on that. We are asking you as a proposition of law. Just because the plaintiff says this is commercial in nature, will that decide the nature of the suit, or can the court look into the substance of the suit?
My Lord, I'll tell your Lordship, my demurrer application was allowed. The plaint was rejected. Your Lordship knows, my Lord, at the demurrer stage, when I'm seeking a rejection of the plaint, my Lord, the plaint has to be taken as sacrosanct. And, my Lord, if your Lordship sees the averments made in the plaint, they themselves say that they took this property to construct a township.
All right.
My Lord, they are
that is enough.
I'm sorry. Very well, my Lord, I should show your Lordship, my Lord, one judgment, my Lord, Patil Automation. Copies now next. Just give me 2 copies. So,
We are somewhat acquainted with this. Every day, this is being cited thrice before us. So,
Just two paragraphs, my lord, I'll show your lordship from this judgment. My lord, if your lordship kindly takes paragraph 113.1.
দিয়েছিল আগে? না, না, দেয়নি। এটা কে দিয়েছে? ওটা কি? হ্যাঁ, তো একই তো। সেম কেস। এটা ফেরত দিয়ে দাও। Yes.
Yes, my lord, if your lordship kindly takes para
Mandatory.
113.1.
Mandatory, we've seen.
Mandatory, my lord, 1 point with regard to the cutoff date. That's why I wanted to show your lordships this. My lord, 113.1 says 12 capital A is mandatory, and the effective date for 12 capital A to be mandatory is 20th August 2022. My lord, however, if your lordship finds 113.3, it says finally, if the plaint is filed violating, my lord, I'm saying this because
When was the plaint filed?
May 2022.
May 22.
But I'll show your lordship. 113.3, my lord, is very important because it says that finally, if the plaint is filed violating section 12 capital A after the jurisdictional high court has declared 12 capital A mandatory also, the plaintiff will not be entitled to the relief. My lord, I'll show your lordship one more judgment of our high court, my lord, which shows the cutoff date. Now, this is Lakshmi Polyfabs, my lord. Lord, your lordship has Lakshmi Polyfabs because this indicates the cutoff date for our high court. Lord, if your lordship kindly takes para 60 of the judgment, Lakshmi Polyfabs. Lordship has that.
Para?
60.
16.
60. In view of the discussions above, the first issue is answered by holding that Section 12 capital A of the Act of 2015 is mandatory. In respect of suits filed up to December 11, 2020, the plaintiff cannot be non-suited for non-compliance as the requisite infrastructure under Section 12 capital A was not notified. Hence, my lord, the cutoff date as far as, my lord, our High Court is concerned is 11 December 2020. And if this is read along with, my lord, para 113.3 of the Honorable Supreme Court's judgment in partial automation, then, my lord, the plaint has been filed post the cutoff date. And hence, my lord, they should be non-suited for this.
Yes.
Lord, and one last submission. This particular land was being used by us for manufacturing automobiles, Lord Ambassadors. Thereafter, my lord, while the land was being used for commercial purposes, my lord, the sale deeds were executed in 2008 to a real estate company for constructing the township. Hence, my lord, the land has always been used for commercial purpose, and accordingly, my lord, it's a commercial dispute under Section 21C. And since, my lord, the plaint has been instituted sans 12 capital A leave, my lord, it has been rightly rejected.
This was one of the grounds that it's a commercial cause but filed in the non-learned
Yes,
judge.
my lord, orally argued. orally argued by us.
In the order rejecting.
Yes.
Yes, that's all.
I'm great. That's all. Great.
I know, Mulad, I've been led by Mr. Banerjee. Mulad, till such time, Mulad, he comes, Mulad, I'll try and Mulad.
What do you mean till such time?
Mulad, I'll tell you, Lordship, Mulad, I'll try and Mulad finish it. I do not think, Mulad, there is Mulad must to be Mulad submitted after Mulad. He has Mulad made his submissions. Mulad, with regard to Mulad, the suit Mulad filed before the Srirampur court, Mulad, your Lordship has Mulad seen the plaint. Mulad, it is in
Forget about order to rule 2 for the timing.
Very well, Mulad, with regard to the commercial dispute now. Now, if your Lordship kindly takes Mulad, the suit Mulad, which has been filed before this honorable court, Mulad, which has been Mulad dismissed, Mulad, is a suit Mulad, where Mulad, we are seeking Mulad damages Mulad, on account of Mulad, money paid to the corporation, on account of Mulad, mutation charges, which Mulad, arrear property tax, which they have not paid. That's Mulad, the crux of the matter. Mulad, a suit filed in view of Section 70 of the Contract Act, that if I have done something, I have not done it gratuitously. So I want a compensation for the amount which I have paid already to the corporation, because they have been refusing, or they failed and neglected to mutate my name after I have become the owner of the property. That's my suit. Now, if your Lordship kindly takes the Commercial Courts Act, Section 21C, whether at all Mulad, I fall within Mulad, thereafter Mulad, what will happen after I come within the ambit of a commercial dispute, whether I will be non-suited, whether Section 12A will apply or not, whether it is mandatory, all those.
What about your own statement in paragraph 30?
Mulad, paragraph 30, Mulad, if in my respectful submission, has been, Mulad, till such time, Mulad, I have joined in the chamber.
You have drafted it.
Yes, Mulad, has been. Till such time, I have joined the chamber where we have Mulad stated that Mulad, the transactions between the parties being commercial in nature, the interest being charged will be as per the commercial transactions charged by nationalized banks. But that does not say, in my respectful submission, that the disputes between the parties are commercial in nature. There is no admission that the disputes between the parties are commercial in nature.
But the transaction is commercial.
Transaction charged by nationalized banks for charging interest is commercial. That is the Mulad. If your Lordship kindly takes Mulad the plaint once, Mulad page 15, Mulad paragraph 30. Kindly takes Mulad the averments made in the plaint. Paragraph 30, it says Mulad the plaintiff therefore seeks a decree for a sum of rupees such and such against the defendant number 1. Thereafter, Mulad, the plaintiff is entitled to claim further interest on the said sum. The nature of transaction between the parties is purely commercial, and the rate of interest is not only appropriate and proper, but also necessary to compensate the unjust benefit being enjoyed by the defendant number 1. Mulad, my admission in my respectful submission.
Why have you acquired the land?
Mulad, the land has been acquired for the purpose of development. But Mulad, kindly sees Mulad, my suit before the Honorable High Court, this Honorable High Court, is not because of that. Srirampur Mulad court suit is on account of Mulad, really Mulad, an enforcement of a covenant.
Without your agreement with Hindustan Motors, would there be an occasion to pay the dues of the corporate municipality by you?
Mulad, kindly.
Wouldn't be.
I'll tell you, Lordship. I'll tell you, Lordship. Even
you want
if I
time?
Consider, no. Even if I consider, Mulad, but I've been instructed to Mulad seek time. Very well. I'll come back. I'll come.
Grant us some experience.
Very well. Very.
Mr. Bose, learned advocate representing Hindustan Motors.
Yes, sir.
Limited, concludes his argument. Paragraph. Mr. Sarkar, learned advocate representing the appellant, begins his submission but does not conclude. Paragraph lists the matter.
If it so commences to your Lordship, 25th, Mulad, if it can be, Mulad.
Day after tomorrow.
Day after tomorrow.
25 তারিখ দিয়ে দাও।
And if I have to, submit any judgment, new judgment, I'll furnish a copy to my learned friend.
In advance.
In advance, yes.
In advance. We are permitting you because it's a tricky point, Mr. Sarkar.
Very good. Welcome.
I'm grateful.
I'm grateful.
Item number 10.
May it please, my lords.
You want to do this or number 6? Which one do you want to do? 6 is also your matter.
6, I'm told the paper book hasn't been given to my lords or to me.
No,
6.
They have.
It's one paper book.
No, they have been filed in the department.
Yes.
We have got the paper.
You have.
Whichever you like.
I have got one. I'll come to 6 only. এসে গেছে?
হ্যাঁ, একটা পেপার বুক কটা হবে পেপার বুক?
ওটাই। Then yes. I'll do this one. If
10.
Mr. Kaur is here. Yes.
Very well.
Well, this has an interesting history, this case. The application was for dismissal of the counterclaim under Order 7, Rule 11, which has been dismissed. I have come up in appeal. My learned friend in his counterclaim made a prayer for eviction of the plaintiff. And our contention was...
Your prayer was declaration injunction.
Declaration.
Usual.
No, it's not very usual. I'll come to the facts of that. But their claim, their counterclaim is for eviction. So that we had taken two very ex facie simple points. One was that they have valued their counterclaim at 1,20,000. So there's no pecuniary jurisdiction. And secondly, the rent is 10,000 rupees, not more than 10,000. It is 10,000 rupees. And therefore, the West Bengal Premises Tenancy Act applies. And without a notice, they can't seek eviction.
8. Premises Tenancy Act 1997.
1997. So these are the two straightforward points, but I must tell my lords a bit about the history. Lease had been granted to the plaintiff, my lord, Raja Katra Limited, in 1938. Lease was originally granted in 38. We came in as assignees subsequently, but that original lease was for 51 years. So it ran out in 1989. Now, from 1977, the rent, what was payable, was had been attached by the income tax authorities. So from 1977, every month we've been paying the rent and for the benefit of the landlord. And this continued up to 2009. So our simple case is that they have accepted rent even after the expiry of the original lease. So we continued as monthly tenants. We were tenants at will and we continued as monthly tenants. They accepted rent from us. Now in 1989, it so happened that we had filed a suit saying there is an option clause in the lease that I can get an extension for 31 years. They denied that and the suit was filed. Nothing happened in the suit. 32 years passed. So my learned friends came up at that time and said, even if the suit was decreed, you'll be out because your 32-year lease is gone. So an interesting application was made for judgment on admission. That you have asked for a declaration, you want a 31-year lease. 32 years have passed, so please go. So the basic fallacy in that argument was you did not even execute a 31-year lease to me. And their orders 12 Rule 6 application was dismissed. Thereafter, was dismissed.
No, it's incorrect. My application was not dismissed.
Yes, I've got the orders here. Be that as it may, I have not been evicted. At least I'll stand corrected that I have not been evicted on the judgment on admission. So then, Manoj, they file one of there are 17 or 18 heirs to the original landlord. One of the heirs has filed a written statement, counterclaim, in the year 2020 something. They filed it and they made a counterclaim for my eviction, saying that the 31-year lease, which I intended, would have expired by now, so you have to leave. So that is their claim. So we took out a demurrer application as soon as they made their counterclaim that first of all, if it is to be treated as a suit, their claim is to be treated as a suit. So even if I withdraw my my suit has become infructuous. I had wanted one date like that to exercise my option, but as it happened, from 1989 when the lease expired till 2009, they accepted rent without any demand for rent or demur. They got the benefit. In 2009, long after I had filed this suit, in fact, 20 years after I had filed the suit, 2009, the income tax sent us an order saying that now their dues are fulfilled. The order of attachment is withdrawn. So from 2009 right up to date, we have been depositing the rent with the receiver appointed by this court. And they've been accepting it. They've even made applications and withdrawn some of that money. So 10,000. So the only two points has to be made. If my rent is 10,000, it is not, it comes within the purview of this act. My lord will see section 3. Section 3F, I think. F, my lord. Nothing, section 3 is exemption. Nothing contained in this act shall apply to, my lords, come to F, any premises let out for non-residential purpose which carries more than 10,000 rupees as monthly rent in the areas in the limits. 10,000 is the exact amount that Justice Patheria in 2009 asked us to deposit, and we've been depositing. So I come within
section 6, then you
section
protection.
6. Then, my lord, will see section 6, subsection 4. Without a notice, no notice under the act. Section 6 is protection of tenant against
Month's notice.
Yes, 1 month. Notwithstanding anything contained in any other law in force, no suit for recovery or possession of any premises as on any of the grounds except the ground mentioned in E shall be instituted by the landlord unless he has given the tenant 1 month's notice expiring with the term. So this is my first point. The second point is they have valued it. The pecuniary value is not there. They valued it at 10,000 rupees, 12 months rent, 1,20,000. So their valuation is also wrong on the face of it. Now, what does the learned judge say? That you have not put these pleadings in your plaint. So therefore, that how can you bring the case now? Now, your lordship will see this decision, the judgment, impugned judgment. I think it's 346, volume.
Memorandum.
Yes, I'll just show from 346. Volume 3. Or your lordship may see from the memorandum. The impugned judgment. Now, may I quickly place it? Or your lordship? GA4 filed on behalf of plaintiff, playing for rejection of the counterclaim by D6, defendant 610. On the ground, the counterclaim is below pecuniary jurisdiction and the same does not disclose any cause of action and barred by law. So these are the points that I've already elaborated on. The instant suit was instituted by the plaintiff for a decree of specific performance of the deed of lease of 14th March 38. So there was an option and at a monthly rent of 10,000 rupees. That's the important part. Then the suit was contested by filing a written statement. Then the bone of contention in the written statement filed by the defendant 6X is a counterclaim made in paragraph 15. In view of expiry period for which the lease was sought by the plaintiff for possession of premises 167 Netaji Subhash Road in its entirety jointly with defendant 6-1 in vacant condition in terms of the original lease of 1938 as also the mean profits subsequent to 15th March 2020 for the area constructed according to the sanction, etc. So here, if I may just pause and explain one thing, Bala. March 15, 2020, my proposed lease would have expired. If I had got the suit decreed, or if my learned friends agreed in 1989 to give me a 31-year lease, it's a non-existent lease. And that's been held in my learned friend's application, where he was very quick to say I've made some incorrect statement. I'll place the record, I'll stand corrected. It was held that that lease is non-existent. It hasn't happened. So that was my parallel case. But what happened in reality? I paid the rent, they accepted the rent. And they accepted me as a tenant all these years. And they got the benefit of their income tax dues being paid through this rent. So that's number one. Number two, my lord, if my lord will see, he's asking for the expiry of this imaginary lease. Only then his cause of action begins. If it was in 1989, they filed the written statement, which was 2020 or 2021, they filed the written statement. They took leave and they filed, and the counterclaim was filed. So it was in any event that would have been barred by limitation. If they are saying expiry by efflux of time in 1989, their conduct shows they have received rent. So this was their pleading. Then, in view of the counterclaim, the instant application has been filed. Learned counsel appearing for plaintiff submitted that the lease has expired. Plaintiff tendered rent at 10,000 per month. This brings the tenancy within ambit of West Bengal Premises Tenancy Act. Therefore, the actual valuation of the counterclaim does not come within the pecuniary jurisdiction. That is really all we needed to say, my lord. Then it is submitted that the recovery of possession cannot be made in the way it is done, since the parties are governed by the provisions of the Tenancy Act. The plaintiff cannot be evicted except in accordance with the procedure prescribed by the said Act. Therefore, so my procedure is the 6-4. They have to give us a 1 month notice. They haven't given. Therefore, the counterclaim is barred by law. For evicting the tenant under the provisions of the 97 Act, there should be a proper determination of tenancy and an initiation of a proceeding under the 97 Act, which is absent in the pleading of the counterclaim. Therefore, the counterclaim does not disclose any cause of action. All these grounds are resorted to by the plaintiff to file the instant application for rejection. When learned counsel relies on this judgment in support of its argument. This decision is that 10,000 is within, and more than 10,000 is outside the purview of the 97 Act. So the Act speaks for itself. Now, this is the point Mr. Kaur took in the trial court. Mr. Kaur, learned counsel, although did not file an affidavit in opposition, but assailed the petition on the ground that it offends the provisions of Order 6, Rule 7. According to him, a new ground is introduced without amending pleading. Well, I am not asking for a decree on this ground. I am not amending my plaint. I am challenging his counter-state claim, which is is independent suit, as it were. So the judge was obviously impressed with this argument. Order 6, Rule 7, my lord says, no pleading shall, except by way of amendment, raise a new ground of claim or contain any allegation of fact inconsistent with previous pleadings of the parties, of the party pleading the same. So what they're trying to say, if I give a generous interpretation of this, that you have said in your claim your lease has expired, you are seeking an extension. So you cannot say today that you are a monthly tenant. But there is absolutely no contradiction if I maintain both the stands. I can be a monthly tenant today and tomorrow I can enter into a lease with my landlord, a registered lease. I have certainty over all this period. Monthly tenants don't have that certainty. It can be terminated at any time. So my lord, there's a big difference. So this was the point was taken. Then the findings, only one paragraph. Plaintiff has instituted the suit for specific enforcement of Clause 4 of the deed of 1938, along with praise. Nowhere in plea is taken by the plaintiff that he is a premises tenant under the 1997 Act. It's obvious. I don't need to, in my suit in 1989, I don't need to say what is my status. I'm saying that under this earlier lease, I want to exercise my option. That was the stand then. And he's accepting rent from us and never gave us a notice making any allegation against us or saying that I will file a suit or I'm taking the rent without prejudice, nothing. Then rather, leasehold rights are sought to be enforced herein. Then suddenly, in the application, the written statement itself came in 2021, so it's not suddenly. The plaintiff has taken the plea that he is a tenant under the 97 Act, contradicting the stance taken by him in the suit, opposed to his pleadings. In another way, the plea taken by the plaintiff in the instant application is outside the periphery of the plaint. Therefore, the plea of the plaintiff cannot be accepted or entertained at this stage. I agree with the submission of Mr. Court that no new pleading can be introduced in the application offending Order 6, Rule 7. The decision referred to by the learned counsel of the plaintiff is not applicable. And the 10,000 is within the purview. That's the only ratio of that agreement, of that decision. Accordingly, the GA4 stands dismissed on merit, then suggested issues, etc. Now, earlier, when that application for judgment on admission had been made, that's at page 324. It begins at page 324. 28th of June, 2023. This application for judgment on admission was filed even before they filed their written statement or counterclaim. They hadn't, this suit basically that had been filed, nothing had been done from 1989. Thereafter, when 31 years passed, they woke up, they made an application for judgment on admission. So one of the points also was you haven't made a counterclaim. After this, they have made the counterclaim. But if my lord comes, my lords come to page 323. Oh, I'm sorry, 324 it begins, 324. A lot of decisions were cited, what is holding over, what is tenant at sufferance, tenant at will. But it is not disputed that they have accepted the rent through the income tax, at least from right up to 2009, 20 years. Now, 329 if my lord comes. It is, so I had taken these two arguments there even before their counterclaim. It is further argued by Mr. Ghosh that after expiry of the original lease, the plaintiff became a monthly tenant on the payment of rent of 10,000 per month, coming clearly within the ambit of the Act. At that time, it was not said that these submissions are beyond pleading, etc. Tenancy of a month of a premises tenancy being contractual tenant can be determined only on the specific ground which is absent in this case. No notice to quit was served on the plaintiff. Then Mr. Ghosh further said that the plea of the defendant, number 6X, is that they have not accepted rent from 1989. In such case, if such case was true, the right to sue arose in 89, the claim is barred by limitation. And this is in 2023. Then, if my lord comes after the findings are not so important, page 333, just the last few lines of the second paragraph, 330, I'm sorry, 330. Just the last sentence of that first paragraph of that. The associated question then becomes, depending on the fact finding, whether the plaintiff is liable to vacate the premises. This question cannot be answered at this stage. Renewal of a lease is a claim by the plaintiff which he seeks to enforce. Renewed lease is not an existent fact. So basically the 31-year lease, which they said, now you've admitted you wanted it for 31 years, 31 years is gone, so you go. But there's no lease. Renewed lease is not an existent fact which can be admitted. In fact, there is no existence of a renewed lease which can be admitted. Therefore, a claim cannot be construed as admission in the present context, which claim do not relate to an existing fact. So the learned judge was well aware of this situation, and now on a side wind, if I may put it, that your Order 7, Rule 11's pleading is not consistent with your plaint pleading, and therefore I will not hear it. And he dismiss it on merits. He doesn't even leave the point open. My lord, if my lord comes to volume 2, what is the counterclaim made? Part of it is quoted.
166.
Page 166, volume 2. Now 177. And that's cause title. 166 it begins. It's a long cause title because there are many heirs to the Burdwan estate, my lord. But only one of them have made this application. And only one of them have filed the written statement. And it will come, my lords will come to page 171. 171, written statement on behalf of defendant number 6X. Rent, monthly rent. Now, if my lord comes to paragraph 4. During the pendency of the suit by an order dated 2nd September 2009, the Honorable Justice Patheria should be appointed Mr. Agarwala for the plaintiff. Now, Mr. Agarwala for the plaintiff was appointed as receiver until further orders, and plaintiff was directed to deposit monthly rent. So the word monthly rent is there in the order itself, and no appeal has ever been preferred from it. And their pleadings itself, even in this pleading, they're referring to this deposit of 10,000 as monthly rent. So this is another clue that they never really opposed us continuing in possession and receiving this 10,000 rupees till the date of this order, 2009. After 2009, we have been depositing with the court. Then at 174, paragraph 9, again in the 5th line, the defendant states, from the first line, plaintiff is not entitled to continue in possession on expiry of 15th March 2020. So their case remains on the expiry of the lease that I've been wanting for 31 years and I never got it. But now that it suits them, they're saying that your lease expired on 15th March 2020. As by admission in plaint, which has been rejected, the plaintiff can continue in possession for a period of 31 years from 89 at a monthly rent of 10,000 expiring on such and such. Again, monthly rent is accepted. Then finally, how they have valued this suit. 178. Prayer could. Prayer could. Well, the prayers will have to be read from paragraph 15 because no specific prayer in that form has been made. Paragraph 15, the plaintiff makes a counterclaim in the suit in view of expiry of period for which a lease was sought by the plaintiff for possession of the premises 167 in its etc. on the terms and conditions of the original lease 14th of March 1938. As admitted in the present suit by the plaintiff and mean profits from 15th March 2020. So they are wanting this. Not very clear. Now your lordship will see 178. How have they valued it? 1,20,000. It's not maintainable before the High Court. It's not a set-off claim. A set-off claim can be for any amount. This is a specific claim for eviction. Otherwise, they would not have paid the stamp duty. Because, of course, there's no prayer for eviction. That's a separate matter. It can be read into their paragraphs. There's no claim as such set out. But they call it a counterclaim. So their counterclaim is mean profits from 15th of March. So up to 15th March 2020, they're accepting me as a tenant. Because it's not a registered lease which is beyond the purview of the 97 or the 1956 Act anymore. There's no registered lease. It's not commercial, though. Well, I don't think.
order 7.1 F বলছে যে fact showing court has jurisdiction. 1F এটা দেখাতে
And some, Mr. Gupta points out some basic facts that is always good to remember. My lord, Order 7, Rule 1 says that 1F says the facts showing that the court has jurisdiction must be pleaded. That's number one. And Order 8, my lord, it says that a counterclaim is equivalent to a plaint. I think those are very basic propositions, even if they're there in the CPC, that's acceptable. So we had also cited certain other decisions. I'm not citing them now because we only need, unless my learned friend disputes that 10,000 rupees is outside the purview of the Act, and unless he disputes that he has valued his claim at 120 only, and he's still entitled to do so. And as far as all the other arguments are concerned relating to holding over, etc., which my learned friend made in the earlier order, if I may just go back to that earlier order once, my lord. 324. So there were two prayers, my lord. One was that they take back the money from the learned receiver, which they took back, which whatever I had deposited, and I'm continuing to deposit. And the second prayer was judgment on admission for a decree for eviction. And I said that it was dismissed. My learned friend says that it wasn't, so I stand corrected because we were allowed to take back the rent. The other two prayers were allowed. So at page 331, the application is disposed of after asking the learned receiver to keep on taking the rent. And discovery and inspection was given. So what I meant was that their prayer for judgment on admission was dismissed, and that is a fact. And all these cases on, if my lord will see at page 327, I am not anticipating that my learned friend will cite all these. If he cites new cases, I'll deal with it in my reply. Those are my submissions. It's a straightforward case that this counterclaim is not maintainable before this court, given the admitted facts.
Look, the main issue is, what is the position of a lessee if he continues to overstay beyond the period of the lease? Whether he becomes a monthly tenant or continues to be a tenant under the lease. Well, there are two division bench judgments of this court. One division bench judgment is by Justice P.B. Mukherjee and Mr. Justice Bachchan. And the other is Justice P.N. Mukherjee and Mr. Roy. Both have held that if the tenant is continuing in possession after expiry of the lease, he does not become a monthly tenant. Also, the Supreme Court is also of the same view. I'll place those judgments. Merely by continuing in possession, they do not become a monthly tenant. But under 116 of the Transfer of Property Act, they are a monthly tenant under the Transfer of Property Act, not under the State Rent Act. Lord, what is the case made out here? In 1936, a lease was granted for 51 years with a clause for renewal for another 31 years. Milord, I'll place the document for another 31 years. They filed a suit for extension of that 31 years. The present suit is for extension for 31 years of the lease, not the tenancy. Now, if there is a suit pending for extension of the lease, is it open to them to say that we have become a monthly tenant under the State Act? That's the first question I'll have to address your lordship. The second question that has to be answered is, what is the position of the person who is on occupation continuing imposition. According to the decisions, they are either holding over or they are continuing without any authority. Tenants at sufferance. Now, my lord, let us see the lease first. What is the position? Page 27. My lord, volume 1, page 27. Periods are given at page 15. Yes, sir. Lord, page 31. It is starting from the top of the. I'm sorry, my lord. I'm sorry.
Mr. Kaur, before anything else, please satisfy us on the point of pecuniary jurisdiction. Pecuniary jurisdiction.
Lord, that is so far as the counterclaim is concerned.
Yes, we are on that only. We are only on counterclaim. They are not pressing their prayers in plain. They say it's becoming infructuous.
No, my lord, they have filed a additional written statement.
But today we are only concerned with your, in this appeal, we are only concerned with your counterclaim. They had filed an application for dismissal of your counterclaim, which application has been dismissed, and they have come up against that dismissal order. So today, please satisfy us first, because you have stated in your counterclaim that you value your counterclaim, which is akin to a suit, at 1,20,000.
My lord, if your lordship takes the application that they have taken out, which was dismissed. 333. 333. Volume 3, page 333. Page 333. It starts at page 338, the application. It starts at T342. As your lordship got it, my lord. The counterclaim filed by the defendant number 610 are not maintainable. Paragraph 5 I am reading, my lord. And the whole written statement and the counterclaim does not disclose any cause of action and in any event but by law. The counterclaim of eviction sought by the defendant is not maintainable. Then paragraph 7, the tenancy of the plaintiff is governed by the West Bengal Premises Tenancy Act. Specific pleading.
Ignore that for the timing. Come to paragraph 9.
No, my lord, that is the main defense. That is the main defense of my learned friend. Whether in a suit where they are claiming extension of time for the lease, they can take up this ground. My lord, if this is not there, then the protection they are seeking is not there.
Mr. Kaur, they need not take up any point unless you can show your counterclaim is maintainable in this court.
My lord, if this is decided against me, then they become a monthly tenant.
Again, you are going to the merits of the case. Show us that this court has pecuniary jurisdiction to entertain your counterclaim as framed by your client.
Now, my lord, if your lordship now sees the counterclaim. That is the issue?
Just see paragraph 9 of their application 1, the affidavit in support of the summons.
The valuation of the claimant is much below the pecuniary jurisdiction limit of the honor, and the same is not maintained. My lord, it is not a question of maintainability. It will be transferred to another court. The counterclaim does not go.
Let it be transferred.
No, I will come to that. I'll come to that. What is being now suggested is that it is not maintainable. Assuming the jurisdiction is not there, then it is to be transferred to another court. It's not a question of lack of jurisdiction so far as the other court is concerned. It cannot be dismissed as is. At best, it can be transferred to a court having jurisdiction.
We'll take the point in that court. I have no problem.
That's not a point. Whether you have a right to continue anymore in this.
That can
the
be,
basis of this suit.
Mr. Kaur, that can be decided only when your counterclaim is decided. Who will decide your counterclaim? Which court?
Now, my lord, what is the counterclaim that I have filed? Possession.
Possession and mean profits.
And mean profit.
Yes.
Therefore, assuming that counterclaim is without jurisdiction,
Yes.
that will be, it cannot be dismissed.
We are not dismissing. We'll say it stands transferred.
Therefore, my lord, question is whether this is at all transferable to the court or this court will decide. Question remains whether the main issue is whether they can continue in possession after expiry of the pleading.
We will not decide that until you convince us that this is the court which must decide.
Milord, may I then place the two judgments? What is the position of the lessee after he
Again,
expired?
Again, that is on a question of whether he continues under the lease or becomes a monthly tenant. We are not on that. Which court will decide that issue?
Very well, Milord. So far as the tenancy is concerned, your lordship will decide whether they're continuing as a lessee or not. That is a question to be decided by this court.
That is a question in your counterclaim.
No. What I'm saying is whether they have a right to continue under the lease. What is their position after the expiry of
If they don't press their suit, if they
let
don't
be decided, let it be dismissed. Let it be dismissed.
file an application for dismissal. File an
I
application for
had
dismissal.
taken out that application, but that was decided on a wrong footing.
Mr. Kaur, we do not see how, in the face of your averment in the counterclaim, that you value your counterclaim at 1,20,000. How High Court will have jurisdiction?
Lord, again, I repeat, my lord, it's not a question of dismissing that claim. At best, it can be transferred to a court having jurisdiction.
We will transfer it.
That is relating to counterclaim.
Correct.
Only. But what happens to your lordship will then decide what is the position of the lessee now?
You valued your suit at what sum? In excess of 10 lakh must be.
My suit. 89 was only 1 lakh.
Oh, 89 was 1 lakh.
In the printers. Volume 1.
Can your suit go now? There, no.
It's a property.
There's no application for it. There's nothing left in my suit. It's there. No, it's my learned friend who's tried to steal a march and get a judgment on admission in my suit. But it's not like I have not been asked to advise on that, so I have not said it. But I'm just saying, Manoj, as far as my plaint is concerned, 1,20,000 because that time it was 1 lakh, the jurisdiction. They've copied this into the counter statement without thinking anything. And their right accrued according to them in 2020, not in 89.
2021.
March 15, 2020.
That's right.
And they will have to go by the pecuniary jurisdiction as it was in 2020 and not in 1989.
That's their pleading for the cause of action.
Milord, may I only address your lordship as to what is their status? If that is decided, everything else will go automatically. Because if your lordship is sending me back to
Mr. Kaur, we are not hearing the suit. This is not the trial.
no, Milord, I am not on the trial.
Today we are only concerned with your counterclaim. That is the scope of this appeal.
No, Milord. There are two questions to be decided.
Yes, correct. The one of them pertains to the forum. This court will not decide anything.
Milord, question is whether they can raise the issue that they have become a monthly tenant in this suit.
Please cite what you want to cite.
Milord, I would like to address your lordship as to whether they can claim themselves to be a monthly tenant. If that is so, then your lordship will at least decide whether they're a monthly tenant or not under the State Act. I'll be citing two judgments of this appeal court and the Supreme Court.
Give us the citations, we'll consider.
First is,
You are giving us copies, Xerox copies.
yes, Milord, I will. I will. First is reported in All India Reporter 1965 Calcutta, page 55, which is equivalent to 1964 Supreme Court cases online, Calcutta, page 19. This is judgment. What is the position of a tenant who continues in possession after the expiry of the lease? They do not become a monthly tenant. They continues to be tenant under the lease.
Which paragraphs, Mr.
Milord, paragraphs are, that you will give me a minute. 65.
65 to
That you will give me a minute.
which page? Sir, may I be excused for 5 minutes?
Yes.
Paragraph.
Mr. Kaur, here the question was whether protection under Thika Tenancy Act was available.
They were a lessee. Whether they claim that we have become a Thika tenant.
That is entirely different. Anyway, yes, paragraphs.
Paragraphs. Milord, I have a copy of the Calcutta. Paragraph 11. Sorry, Milord. It starts from paragraph 8. 8, 9, 10, 11, 12, 13.
Paragraph 8 onwards, let us say.
8 onwards.
Perhaps it will be 7 onwards in the SCC online.
Very well, 7 onwards.
And Milord, the next decision. To Calcutta.
Online network.
Milord, other decision is All India Reporter 1982 Calcutta 225, which is also reported in 1981 Supreme Court cases online.
Calcutta 176.
Calcutta 176.
Yes.
Paragraph 15. Supreme Court. Then, my lord, AIR 1998 Supreme Court, P085. Paragraphs 12, 13, 14, 18, and 19. My lord, my submission would be before your lordship that if your lordship is convinced that the position is not that of a monthly tenant, your lordship will hold that and then send it to the court below for adjudication.
Very well. We are listing it as for orders 3 weeks hence. We are not reserving. We'll either dictate in open court. Naturally, we'll have to do that if we are not reserving. Hearing
Tally for your lordship.
Hearing is concluded for all practical purposes. Stop. List this matter once again on July 14, 2025, under the heading for orders. Hey.
Item number 11. Even 12. Stop.
Adjournment.
We started hearing this matter? No. No. We have passed over Mr. Jayanto Mitra's matter.
Yes,
Allow us to take it up. Allow us to take it up.
Only indulgences. Instead of coming back tomorrow, may I come back day after tomorrow?
Absolutely. You can come back any day you want to. Day before yesterday, or
Tuesday.
এটাকে পরশুদিন রেখে দেবে এটাকে
We'll come back day after Wednesday.
তুমি মিস্টার জয়ন্ত মিত্র সাহেবের মামলাটাকে রাখো
The one indulgence, your lordship. Since your lordship is taking up the passed over matter, item number 7 and 8 were also passed over. Where I'm led by Mr. Krishna Thakur. He was there, but he has fixed matters at 3 and 3:45. So if it could stand over till tomorrow, we shall.
Very well. 7 and 6 and
7 and 8.
7 and 8, not today.
7 and 8, not today.
Not today.
Not today.
In any event, Mr. Mitra says he will take up the rest of
the day.
Well, so far, item 11 and 12, which is kept on Wednesday, it is retained its position in the list.
Yes.
So it will come as 11 and 12 only.
No, up in the list. I can't say it's 11 and 12. Obligement.
Passover matter, commercial division, item number 8.
It has been my lord's pleasure to release the other matter. I don't.
Yes. Other matters are released. You're opposing Mr. Mitro?
That's why I readily agree. I'm being led by Mr. Joydeep Gaur.
This is DVC. This is DVC.
Yes. May it please, Lord. My Lord, this is an appeal from an order whereby, my Lord, the application for setting aside of an award has been dismissed by the learned trial judge. So, my Lord, I have come up by way of an appeal. My Lord, this was the dispute arose between DVC and, my Lord, BLA projects, the appellant and the respondent. My Lord, in connection with, my Lord, and a contract under which, my Lord, the coal was to be transported from a railway siding to, my Lord, the Raghunathpur thermal power station. There were 3 sidings which were there. Chaurasi siding, that is the one that we are concerned with. And there are 2 other sidings from which, my Lord, this coal was to be transported. The allegation is, my Lord, the dispute is that in the matter of supply of coal, rather transportation of coal from one place to the other, from the railway siding to the, my Lord, RTPS, my Lord, their plant, the allegation is that this BLA projects, private limited, the respondent, had, my Lord, mixed coal with, my Lord, other things, particularly mud and stones. So, on the basis of a contract which was entered into, there is a particular clause that if there is, my Lord, the language is, if there is a corrupt practice or fraudulent practice in the matter of execution of the contract to the detriment of DVC, then, my Lord, DVC will be entitled to terminate the contract. So the dispute arose between the parties as to whether there was a fraudulent or corrupt practice in terms of the contract. It was held, I shall give your lordship, my Lord, the chronology of event. It was held, my Lord, by DVC that there had been a corrupt practice. Because, my Lord, they had been, in the matter of execution of the contract, they had been mixing up coal, which was to be transported. They have mixed it up with, my Lord, various unwanted objects like mud, stone, etc. And, my Lord, the contract was terminated. So, BLA projects came up in an arbitration against DVC for wrongful cancellation of the contract.
Section 11 appointment or?
Appointment, my Lord, this was by section under section
11.
Yes, section 11. And, my Lord, the London arbitrator had given an award under which he held that in so far as the contract is concerned, that the contract had been wrongfully terminated. He had given some interpretation of fraudulent and corrupt practice, interpreting the provisions of the contract. Well, I have got twofold submissions on this. First is that his interpretation, it's not a question of fact, it's a question of law. And, my Lord, his interpretation is a perverse interpretation of the terms of the contract. He did not, the learned arbitrator, my Lord, did not fully appreciate the meaning of the terms. I shall presently place that clause before lordship. That is one. And secondly, by reason of the fact that he proceeded erroneously on the interpretation of that particular clause, he did not take into account any evidence which was led with regard to the factual basis with regard to corrupt practice. In other words, what I'm saying is this, it is not really an failure to appreciate the evidence. It's a failure to take note of the evidence altogether. That is the perversity that had come in. So on these 2 grounds, my Lord, I have challenged this. Now, my Lord, I will request your lordship first to look into the terms of the contract. So that, my Lord, it is a short point involved, very short point involved, and the award is a very short award. It's not a very long award because, well, the arbitrator had confined himself to the interpretation of the particular clause And by reason of the interpretation, he had excluded the evidence with regard to corrupt practice which had been led by my client. In the award, my lord, there is no discussion with regard to the evidence at all. Now, my lord, I will just draw your lordship's attention to these clauses. My lord, kindly first of all take the this is an contract dated 23rd March 2011. This is, my lord, called annual rate contract.
How many volumes are there? Paper book?
There are quite a few volumes, my lord, but I will not trouble your lordship with this. Kindly, my lord, I shall confine your lordship to, first of all, to volume 4. Yeah, 20 an annual rate contract. This is, my lord, volume 4, my lord, kindly take. I have not been able to get myself acquainted with the computers. I wish, my lord, I had. My lord, many of my juniors had promised to teach me as to how to use the computer, particularly liquid test. The liquid text, my lord, I have not been able to use, so, my lord, I have to carry all these volumes. And, my lord, I envy my learned friends. Oh, it's the same thing with you.
In fact, I get more confused when the screen all of a sudden goes up and comes down.
I don't even try, Mr. Dutt. A lot of the juniors have gone paperless, as they say.
Absolutely, my lord. All the juniors sitting, my lord, next to Mr. Dotto.
In fact, my lord, I went for an outstation arbitration, my lord, and my junior was carrying this tab, and I was to carry my brief. So I requested him if you could share the button. He said, I am carrying my papers, you carry yours.
Yes. Volume 4.
Yes, volume 4, page 450. This is the annual rate contract which was entered into between DVC and BLA projects. This your lordship will please to find. 23rd March 2018. I am not troubling your lordship with the entirety of the clauses. I go straight to this. Only thing is this, first paragraph your lordship sees addressed to BLA projects. With reference to above, Damodar Valley Corporation is pleased to place this annual rate contract in you for transportation of 12 lakhs metric tons of coal from different collieries, coal washeries of BCCL, CCL, etc., any other coal companies to RTPS, Raghunathpur, in rail cum road mode by using Chaurasi railway siding in the distance range of approximately 30 kilometers from the unloading point of RTPS for a period of 1 year with effect from 26 to 2018 as per the rate given in the Annexure A. The detailed scope of work along with terms and conditions has been mentioned below. In addition to this, the relevant terms and conditions of general conditions of contract GCC of DVC shall also prevail. So this is the paragraph. Now, your lordship will kindly turn on the pages. And kindly come to page 451, clause 2. 451, clause 2. No contamination of coal for use in TPP. You shall ensure with the railways that iron ore or any other material which can contaminate the coal for use in the power plant is not brought in the siding or in the portion of it allocated to DVC during the pendency of this contract. And then, my lordship will be pleased to come to clause at page 461. This is the important clause on which the whole thing is turning. Similar clauses are there. I shall show to your lordship. Clause 14. 461, clause 14. DVC may terminate, short close the contract by not less than 30 days written notice to you to be given after occurrence of any of the events specified in serial numbers A to D of this clause, and 60 days in the case of events referred to in serial numbers E and F below. Now, A, B, C, D. First is you fail to comply with any of the terms of annual rate contract, or you do not remedy a failure in the performance of your obligation under the contract within 30 days after being notified, or within any further period as DVC may have subsequently approved in writing. Then B, you become bankrupt, doesn't arise. C, as a result of force majeure, doesn't arise. Then D, if you, in the judgment of DVC, has engaged in corrupt or fraudulent practices in completing or in executing the contract. Now, I pause here for a moment. Kindly notice the words, because this interpretation of the arbitrator is causing has caused some problem which had brought me to the court. If you, in the judgment of DVC, has engaged in corrupt or fraudulent practices in completing or in executing the contract. For the purpose of this clause, corrupt practice means the offering, giving, receiving, soliciting, or anything of value to influence the action of a public officer in the selection process or in contract execution. And fraudulent practice means a misrepresentation of facts in order to influence a selection process of the execution of a contract to the detriment of DVC. Then E is you are otherwise precluded from complying with any of the terms of the annual rate contract. And F is if DVC at its sole discretion decides to terminate the contract. So these are the clauses which were there, which fail for consideration of the learned arbitrator is with regard to the language of 14D. But my lord, of course, this is the clause in the annual rate contract. After this, my lord, a contract agreement was executed, which is at page 480. This is dated 30th April. The annual rate contract which was awarded is dated 23rd March 2018. On 30th April, a formal contract agreement was executed, and that is at page 480. Here, your lordship, my lord, your lordship will please to come to kindly come to, my lord, the relevant clause which is at which is clause 11. First of all, come. Cancellation / termination. Applicable as per clause 14 under general terms and conditions of the annual rate contract. Now, this is, my lord, at 461, your lordship is pleased to see. So it is reiteration of what is contained in the annual rate contract. Then, my lord, there is another clause. Your lordship will be pleased to come to the general conditions of contract. GCC has been referred to, annual rate contract, general terms and conditions. The GCC is, my lord, in volume 3, page 408. Similar clause. Volume 3, page 408. At, my lord, page 415. Page 415. 410 is the general conditions of contract. But I am drawing your lordship's attention to this because, my lord, your lordship is pleased to see in the formal agreement that references to the general conditions of contract. So this is the general conditions of contract, and clause 17 at page 415. Your lordship sees a similar clause. The owner may terminate, short close the contract by not less than 30 days written notice to the bidder to be given after occurrence of any of the events specified in serial numbers A to E of this clause, and 60 days in the case of events referred to in G, H, and F below. In this, my lord, clause A, B, and C, I am not troubling your lordship. Can we come to D? If the bidder, in the judgment of the owner, there is some difference in language. If the bidder, in the judgment of the owner, has engaged in corrupt or fraudulent practice in competing or in executing the contract. For the purpose of this clause, corrupt practice means the offering, giving, receiving, soliciting, or anything of the value to influence the action of the public official in selection process or in contract execution. Now, my lord, these words have been used, my lord, indiscriminately. Selection process or in contract execution. Now, contract execution, does it mean signing the contract or, my lord, performance of the contract? The language should have been more clear. Because it is not clear, it has created some amount of confusion. I am interpreting in one way, my learned friends clients are interpreting another way. And, my lord, the learned arbitrator has agreed with my learned friends' interpretation. I am submitting to your lordship that engaged in corrupt or fraudulent practice in competing or in executing the contract, one is, my lord, at the time of entering into the contract, and the other is, my lord, at the time of performance of the contract. It can't be that you cannot indulge in corrupt practice or fraudulent practice at the time of entering of the contract, but you can do so at the time of execution.
What has the arbitrator held?
Arbitrator has held this is at the time of entering into the contract.
Subsequently, there is no obligation not to indulge in corrupt
Not
practice.
So, my lord, if anybody does not supply the contracted quality of goods, but, my lord, indulge in, my lord, I should say, I won't use the word corrupt practice, but, my lord, misdemeanor in the matter of, my lord, mixing up the coal with mud, which is possible, or, my lord, stone and things like that. And, my lord, kindly remember one thing, that these are being transported to Raghunathpur thermal power station, and these go into the boiler. So, my lord, it is not something which one can take it lightly in the matter of supply of materials. That is why, my lord, a specific provision is there. The materials will supplied will be
Maybe of academic interest, Mr. Mitro. If this clause was not there, let us say,
yes,
and you found that the coal that the contractor is supplying is actually mixed with mud or other things, stone chips, would you not have been entitled to terminate?
Then perhaps, my lord, I mean, I am arguing against myself. Perhaps my learned friend will say clause A will apply.
There is a provision for it.
Yes, I mean, it can't be that he's giving me substandard coal.
Right. So I am submitting to your lordship that if a totality of these terms of the contract are read all together, then one has to come to the conclusion that you cannot indulge in corrupt practice or fraudulent practice at the time of entering into the contract, nor can you indulge in any corrupt or fraudulent practice at the time of performance of the contract. Both, my lord, are governed by this. And, my lord, your lordship sees almost the similar terms in different documents. The terms are, and, my lord, kindly see, kindly come, my lord, to page 415. The first is corrupt or fraudulent practice in competing or in executing the contract. Then, for the purpose of this clause, corrupt practice means the offering, giving, receiving, or soliciting of anything of value to influence the action of the public official in the selection process or in contract execution. And then a fraudulent practice is mispresentation of facts in order to influence the selection process or the execution of a contract to the detriment of the owner. So, my lord, this the reason for I shall come to that. There is one other provision I would like your lordship to look into. That is, my lord, optional. This is called optional. Means that has been taken note of by the arbitrator. This is in volume 4, na? 4 to 5. 4 to 5. Huh? This is optional terms 4 to 5. Page 4 to 5 of the same volume. This your lordship will be pleased to find. My lord, kindly come to the next volume. If this doesn't end here, it goes on to volume 4. It goes into volume 4, clause, page 435. 438, sorry, 438. This is called optional terms and conditions. As your lordship will please to find at page 4 to 5, continuing at page 4 to 8. And here, my lord, again 24.2. This has been referred to in the award, so I am placing it before your lordship. The difference, kindly see. The employer without prejudice. 438. 438, volume 4.
54.2.
438, clause 24.2, termination for contractor's default. The employer, without prejudice to any other rights or remedies it may possess, may terminate the contract forthwith in the following circumstances by giving a notice of termination and its reasons therefore to the contractor. Referring to this GCC subclause 24.2. A, don't trouble your lordship. B, I do not want to trouble your lordship. C, if the contractor in the judgment of the employer has engaged in corrupt or fraudulent practices in competing for or in executing the contracts, then for the purpose of this clause, corrupt practice means the offering, giving, receiving or soliciting of anything of value to influence the action of a public official in the procurement process or in contract execution. Then fraudulent practice means a misrepresentation of facts in order to influence a procurement process or in execution of the contract to the detriment of the employer, and includes collusive practice amongst bidders prior to or after bid submission designed to establish bid practices at artificial non-competitive level to deprive the employer of the benefit of free and open competition. So, my lord, these are the clauses I have shown to your lordship, which came up for consideration of the learned arbitrator. Now, my lord, before I take your lordship to the relevant portion of the award, I must tell your lordship, my lord, certain proceedings took place in court. My lord, first is, my lord, DVC issued a notice complaining of coal contamination. This your lordship will be pleased to find in the same volume, volume 4, page 489. This is the genesis of the dispute. I shall give your lordship a list of dates. Perhaps it will be easier for your lordship. Just giving the dates. This is page 489, dated 2nd June 2018. This is issued to BLA Projects. Dear sir, this is to inform you that the following vehicles transporting coal from Chaurasi siding to RTPS were caught red-handed while dumping contaminated coal with mud at RTPS unloading point. The photographs of contaminated coal dumped at unloading point are attached herewith. The vehicle's numbers are as follows. Then vehicle numbers have been given. Next paragraph. Moreover, from the written declaration given by the drivers of these vehicles, it transpires that they resisted at the siding against loading of contaminated coal. But your siding management personnel forcefully loaded the contaminated coal in the vehicles. The incident is being viewed seriously by RTPS management, and appropriate action shall be taken against you as per provision of the work order. Then, my lord, at page 497, and my lord, there your lordship will please to find the annexed is the persons writing, my lord, I can hardly read them. আমি বাংলাটাই পড়ব আমরা সোয়েনসো সাইট থেকে 490 well the annexure to this letter are, my lord, the evidence of this contamination of coal and written by, my lord, the drivers. আমরা 84 সাইডিং হই করেছিলাম সাম ঠিকানা ডিভিসিতে খালি হাতে হঠাৎ অসুবিধে হবে, তখন তিনি বলেন যে
আমরা দেখে নেব
তোরা মাল নিয়ে যা, আমরা দেখে নেব. Like this, my lord, there are certain documents which have been given, and my lord, I take your lordship straight to then, my lord, there is a letter of BLA. This is at 493. It can't be read, so kindly come to 493A. This is dated 5th June 2018. This also is not very clear, but anyway, let me try and read it. We acknowledge your above referred letter and the matter described in it, which was raised totally due to unfortunate circumstances. We have been associated with DVC for more than 2 decades, and it is well known that we do our business with a lot of integrity. Your letter dated 2nd June 2018 blatantly accused us of being criminals, and the words like caught red-handed belittle our association of so many years. Some facts with regard to the same may be noted. A. We started the work on 28/3/2018 at Raghunathpur and have already transported more than 135,000 tons of approximately 7,500 trips. But this is the first time such incident has occurred, and we hope that you understand it was not our intention to transport soil along with coal. Then you are well aware that the transporting was lost for 7 to 10 days due to the local transporters association issues, which led to increased coal stock of about 7 to 8 rakes. It is also known to you that number 3 railway siding at Chaurasi is not concrete and paved, and the payloaders and dumpers were flying over the coal during the transporting period past 5-6 days, resulting in coal automatically mixing with soil and mud. Therefore, my lord, there is some admission. On 1st June 2018, there was heavy rainfall in the evening, and when the coal was being loaded into the tipper with chipping to recover all the coal, it got mixed with mud and soil, which is quite natural and highly impossible to avoid due to nature of the siding, kacha siding. Then, my lord, 494A. E. As well as your engineer, Mr. S.N. Prasad and Mr. Rajesh Pathak and Mr. Ankur Mandal have also visited the site after rain, and they know all the facts of the site condition. Till date, from the date of commencement of the work, only 3 tippers with this type of mixed coal, and that was also due to circumstances out of our hand. Still, we regret and assure you that we will be more aware in avoiding such situation in future. But we are very disappointed that your representation of statements caught in record red-handed had been made without putting in perspective all facts. Sir, however, you have stopped the placement of rakes from 2/6/2018 onwards, and we are hopeful that you will understand the circumstances and condition of work and advise us about the future procedure. Therefore, there is, my lord, an admitted position, whatever may be the reason, that there had been some mixing up of coal with mud and other things. Then, my lord, BL is another letter of 5th June. It is a repetition of the same thing. My lord, then your lordship will please to come to page 497. This is the cause of action for my learned friend to raise the dispute. This is addressed to BLA project by DVC, and the subject is transportation of coal, and reference has been given to the letters. Reference to the annual rate contract as stated under reference 4 above. It has been reported that during transportation of coal from railway siding to DVC RTPS plant on 1st June 2018, you have unloaded coal from the dumper at the backyard of a roadside weighbridge. It has also been reported that inferior quality of coal mixed with extraneous materials were loaded in the empty space of the dumpers and were transported to RTPS plant and unloaded at the track hopper directly. Subsequently, on 2nd June 2018, the same recurred and was unloaded at track hopper directly in spite of repeated warning by RTPS authority. The unloaded heaps at the track hopper on examination was found full of mud and stone. This is considered a corrupt practice and fraudulent practice as per clause 17 DEA of GCC and clause 24.2 of additional special condition of contract with the heading termination for contractor's default of the referred contract. This sort of corrupt practice and fraudulent practice is detrimental to the interest of DVC and has been viewed seriously. In view of the above, DVC hereby invoke clause 24.2 in totality, that is termination of contractor's default of the additional special conditions of contract under the head optional terms and conditions of contract over and above clause 17 of GCC of the referred contract, and terminate the referred contract with immediate effect by clauses as stated herein above. As per terms of the contract, you are liable to compensate DVC for all losses arising out of the corrupt and fraudulent practice adopted by you due to termination of the contract. Then, my lord, the invocation of bank guarantee at 498. I am not troubling your lordship. This is a consequential letter which has been. Now, my lord, after this termination notice was given, they came to this honorable court in a 226 application. And on that, my lord, an order was passed at page 508. This is, my lord, at page 408, dated 18 June 2018. The order was passed by Justice Tapobrata Chakraborty. Supplementary affidavit filed with the petitioners kept on record. Heard Mr. Mukherjee, learned senior advocate appearing for the petitioner. In course of hearing, so and so, appearing for the respondent number 1 to 3, submits that the authorities of Damodar Valley Corporation, in short DVC, have agreed to withdraw the memo. Kindly note, agreed to withdraw the memo dated 6 June 2018, issued by the Chief Engineer Mechanical, and the memo dated 14 June 2018, issued by the Superintending Engineer Fuel. But this is, your lordship can make a note of it. This 6 June is at page 497, which I showed to your lordship. And my lord, the 14 June is in the same volume, page 505. In view of, this is a letter of termination. In view of such submission, the writ petition is disposed of. My lord, kindly note these words. Agreed to withdraw the memo dated. So, my lord, I withdrew the note, these two memos on behalf of DVC. And then, my lord, in view of such submission, the writ petition is disposed of, granting liberty to the petitioners to submit a reply to the memo dated 2nd June, issued by the superintending engineer, fuel management, etc., within a period of 2 weeks from date. The said reply shall be submitted to the Executive Director Projects DVC. Upon receipt of the said reply, the Executive Director Projects DVC shall consider the same, and upon granting an opportunity of hearing to a representative of the petitioner, and take a fresh decision and communicate the same to the petitioner within a period of 2 weeks thereafter. It is made clear that the Executive Director shall consider the petitioner's reply without being influenced by the contents of the memorandum dated 6 June 2018 and 14 June 2018. Naturally, my lord, since the DVC withdrew these two letters, therefore, my lord, Executive Director was directed to consider the representation without being influenced by these two letters. Then, my lord, on the basis of this, the letter was, a representation was made at page 510 by BLA Projects. I'm not troubling your lordship with the entirety of it. And then, my lord, at page PLA made a representation at page 521. This is, my lord, in pursuance of the order which was made. At page 521, letter dated 29 June 2018. Well, if I may just quickly place it, my lord, the relevant paragraph. The first paragraph, need not trouble your lordship. This is with regard to the order which has been passed. Then, my lord, the next page. The allegations contained in the memo dated so-and-so are regarding the dumping of contaminated coal with mud at RTPS unloading point. The said coal traveled through 3 vehicles, the numbers whereof is mentioned in the letter. DVC is also relying upon written declaration given by the drivers of the vehicle. On receipt of the memo dated 2nd June, we have by a letter dated 5th June, which I showed to your lordship, submitted our reply. On factual score, a copy of the reply is enclosed. We respectfully adopt the contention made in the letter dated 5th June. Additionally, we say as follows. A, the declaration of the said drivers clearly shows that they had lifted the material from Chaurasi siding and had delivered the materials at the site. It further shows that at the stage of lifting the material, they had expressed difficulty. This clearly shows that the mud came from the siding itself. B, we have, by your letter dated 5th June 2018, given an explanation as to why mud came along with the coal. We crave leave to refer to rely upon the said representation. Then C, it is apparent that the presence of mud in the coal was involuntary act, which happened in the context of the situation at the siding coupled with the rain that took place. Then D, in this context, your attention is drawn to the contract clause 13G, which contemplates additional penalties in case of extraneous materials found in the coal at the time of unloading. The contract therefore envisages such situation which may happen during transportation of coal. The contract also provides remedies for such situation as it contemplates penalty. Then there's E, the expression red-handed also features in clause 13G(III), but the same also speaks of malpractice during transportation. In the memo dated 2nd June 2018, there is no allegation of any malpractice. Rather, the statement of the driver supports the contention that there was no malpractice. In the facts and circumstances, and considering that the incident alleged in letter dated 2nd June is covered by the contract clause as stated above, we humbly request you to kindly sort out the matter. It should be sort out the matter in terms of clause 13G. It is really unfortunate that despite the order dated 18 June 2018 passed by the Honorable High Court, wherein you withdrew the memos dated 6 June and 14 June, realizing that the same were unsustainable, we have not been permitted to work by DVC. Although the contract is alive, but effectively we have been made to sit idle without any work since 2nd June 2018. We therefore request you to redress the grievance. Then, my lordship, will you please to come to, I am not troubling your lordship with these other things. Kindly come to, my lord, straight away to the impugned order. This is at page 556 of the executive director in the same volume. On the basis of these written representations and hearing, my lord, this reasoned order was passed at page 557. First paragraph, the order has been referred to. Then, my lord, paragraph 1, in terms of the Honorable High Court order, submitted a reply dated 29/6, issued by the superintending engineer. Then further, as per the order, a hearing was fixed by the undersigned on 25/7/2016 at DVC headquarters, wherein both parties, DVC and BLA, were called. Representatives of both parties were present in the hearing. Statement of DVC and Mrs. BLA as recorded is placed as Annexure D. Then, my lord, Mrs. BLA stated that their reply dated 5th June and 29 June clarifying the matter against allegations made by DVC while letter dated 2nd June stands, and they have no further submission in this regard. DVC was asked to explain the reasons and contractual provisions thereof for termination of the contract by letter dated 6 June 2018, which was subsequently withdrawn by DVC in the High Court, Honorable High Court, on 18 June 2018. DVC representative stated that based on the report of RTAPS authority for adopting fraudulent practice by Mrs. BLA in transportation of coal from Chaurasia siding to RTPS plant and per internal directive of the Vigilance Department, based on their investigation, the contract was terminated, invoking special conditions of contract 24.2.1, wherein the client is entitled to terminate the contract forthwith due to corrupt and fraudulent practice adopted by the contractor. In reply to my query that what fault was made by the contractor during the execution of the contract, DVC representative from RTPS narrated the incident mentioned in SEM Fuel Management letter dated 2nd June issued to BLA. They also mentioned the video recordings of the incident is also available with Vigilance Department RTPS. On my specific query to whether the happening of fraudulent practice was witnessed by any of the representatives present at the hearing, it was informed that they have not witnessed the activity in person. That means the persons who are present there. However, the Chief Engineer O&M RTPS DVC informed that in earlier occasion on 24/4/2018, he witnessed flying of some dumper with coal rejects in place of coal and observed suspicious activity at Chaurasi siding by Mrs. BLA. Detail placed in the written submission during hearing. Immediately, he called Mrs. BLA local representative and cautioned him and asked him to refrain from such activity in future. He also stated fraudulent activity on 2nd June 2018 has been witnessed by Vigilance Department and they have recorded the same. Accordingly, drastic action against Mrs. BLA was recommended from RTPS. Executive Director Fuel stated that considering the serious nature of allegation against BLA, he endorsed for termination of the contract. BLA's representative was asked for his submission on DVC's allegation of adopting fraudulent practice. Mrs. BLA informed that they will submit written submission within 12 days on this issue. Subsequently, Mrs. BLA furnished submission on 6/8/2018. In their submission, Mrs. BLA stated the following. 1. The letter of 2nd June 2018 of DVC was related to dumping of contaminated coal at unloading point. Therefore, the scope of hearing shall be restricted to the issue related to letter dated 2nd June 2018. They also reiterated their stand as per reply given in the letter dated 5th June 2018 and 29 June 2018. Regarding discussion on reasons of termination of the contract in the hearing, Mrs. BLA stated that the issue may not arise since the termination was withdrawn by DVC. BLA refuted this termination notice issued by DVC invoking contract clause number 24.21c of special conditions of contract by letter dated so and so. Since additional special conditions of contract is not part of the contract agreement. Mrs. BLA stated the incident of 24th April 2018 as described by the Chief Engineer O&M RTPS in its statement during hearing was not communicated to them by DVC. Mrs. BLA refuted all allegations made by DVC representative in their submission regarding fraudulent practice during transportation of coal from Chaurasia siding to RTPS plant siding. Mrs. BLA mentioned contract clause 13G of annual rate contract, which had provided additional penalty for mixing of mud with coal exceeding certain percentage. They mentioned that mixing of coal with mud happened only in the instant case. So, there is an admission, and they said that you could have imposed some other punishment instead of terminating the contract. On perusal of all documents, records are submitted made by both sides, my findings are as follows. As per the letter dated 2nd June, DVC it is established that malpractice has been done to mix mud with coal in 3 numbers of dumpers found by RTPS DVC authority on 2nd June, coal year. Written statement of dumper drivers corroborate the fact in the instant case. Mrs. BLA's argument of mixing mud due to rain in the unpaved siding in Chaurasia is not tenable. In terms of the High Court directive wide order dated so and so, the following was mentioned in the order. Then the order has been quoted. Hearing has been held to hear, but in italics I am ignoring that because that is the order which I have placed before Lordship. Hearing has been held to hear both parties and their submissions covering entire issues. Mrs. BLA submitted in their reply dated 6/8/2018 that hearing cannot go on beyond the contents of the letter dated so and so, which relate only 3 numbers of trucks found with mud mixed with coal on 2nd June. In my opinion, to arrive at a decision on this issue, discussion should not be restricted within the contents of the letter dated 2nd June. Representative of DVC alleged fraudulent activities by BLA, the contractor based on internal investigation by DVC's Vigilance Department, Chief Engineer so and so, stated an incident on 24th June 2018 for adopting improper practice by BLA observed by him during his visit to Chaurasia siding. Subsequently, Mrs. BLA representative was cautioned against such fraudulent activity by him. Executive Director DVC also expressed the concern on the serious nature of malpractice reported by DVC RTPS, and the same had prompted him to recommend termination of the contract as a penal action against such act. There was no documents furnished by DVC as a written communication to Mrs. BLA, the contractor, for adopting fraudulent practice in the past before the letter date so and so. However, the statement of engineer so and so and the executive director indicates happening of such events in the past also. Mrs. BLA in their written submission dated 6/8/2018 stated that clause number 24.2.1c special conditions of contract is not applicable to the contract in question, and therefore DVC wrongly invoked the said clause of contract for termination forthwith as communicated by their letter dated 6 June 2018, which was subsequently withdrawn by DVC. On examination of the contract document, it is found that the same is part of NIT document. Under additional special conditions of contract, and both parties are bound by such NIT contract. As a natural justice, the contractor should be given opportunity to submit their views against the allegations made by DVC in their letter dated 2nd June. DVC has received reply dated 5th June from BLA on this issue. In view of the above, I found the fraudulent activities, etc., and fraudulent activities in the activities on coal transportation from Chaurasia Sandik to Raghunathpur Thermal Power Station occurred, and Mrs. BLA so and so can't deny the fact that has been established in the proceeding. Therefore, DVC made the decision on termination of the contract or otherwise in terms of the contract provision. Now, my lord, after this happened, then, my lord, the matter was referred to arbitration. In a proceedings,
There must be a formal termination letter
There
after
is a
this.
formal termination letter. I'm giving your lordship that. That is at volume 5. Volume 5, 586. At 587. Dated 5th September 2018. Dear sir, subsequent to the Honorable High Court Calcutta order against writ petition number so dated 18 June and the hearing in the Office of the Executive Director Project dated so, a reasoned order has been passed, number so dated 5th September 2018. Reference number so above. In view of the above referred, the contract is hereby terminated by DVC with immediate effect. So this is the formal letter, page 587. Page 590 is the order appointing arbitrator. My lord, there was an arbitration clause in which, my lord, the chairman of TRF Limited was to be appointed.
So the amendment and the 7th schedule.
So, my lord, that has been referred to by the learned judge at 591, and my lord, Mr. Sarkar was appointed the learned sole arbitrator. And thereafter, my lord, the arbitration proceedings went on before him. Now, my lord, I am not going to trouble your lordship with anything else for the time being. I shall refer back to the statement of claim, the averments, etc., if necessary. But I take your lordship straight to the award. That your lordship will be pleased to find. Volume 8, page 1094. ঠিক আছে, এখন এটা নিয়ে আরম্ভ করো ভাই, তারপরে 8 and 9 দিতে হবে। Well, it starts at page 1094. It's a short award. I am not troubling your lordship with 1094, 1095. The background has been given. I have given the entire background to your lordship. Page 1095, 1096. The facts have been stated. Then writ petition has been referred to at paragraph 4. Then, my lord, the letter of 14 June has been referred to in paragraph 5. Then writ petition was disposed of paragraph 6. Then paragraph 7 is, kindly note this. Following the said order, para 7, at page 1098. This is important. Following the said order and consequent upon withdrawal of the said purported letter of termination dated 6 June, the claimant by letter date 22nd June asked the respondent to release the bank guarantee, etc. Then, para 8, faced with such all-round uncertainty, the claimant by letter dated 5th July invoked the arbitration clause in the agreement. Then, my lord, paragraph 8, then paragraph 9, the reason order was served at paragraph 9. And then, my lord, the matter was referred, then the disputes at page 1314. The disputes have been whether the agreement dated 30th April has been lawfully terminated, the first issue, and second issue with the claimant respondents are entitled to money claims or compensation as raised in their respective pleadings. The matter on merit. It is thus clear that the contract and the crucial issue in these disputes between the parties is whether the contract between the parties has been lawfully terminated. In this context, I should make one fundamental point, and this is very important. Quite clear at the outset, in view of the contention raised by the claimant in these proceedings before me, that the decision to terminate the contract as embodied in the order dated 5th September 2018, the respondent disregarded the clear direction by the order dated 18 June 2018 passed by the learned judge to the effect that in deciding the issue on termination, the respondent should not be influenced by the memorandum dated 6 June 2018 and 14 June. It should be 14 June 2018. The point relates to whether as arbitrator, I should be obliged to disregard contents of the said two documents from consideration in deciding the validity of the purported termination of the agreement. I say no. So, my lord, even though the court said you ignored this, the arbitrator said no. As an arbitrator, my jurisdiction and power is derived from the arbitration agreement and order of reference. This is an independent jurisdiction and by no means was continuation of the proceeding before the writ court, which was only concerned with the issue whether the conduct in terminating the contract of the respondent as the state authority was arbitrary or unreasonable. As such, I am not affected by the directions of the writ court and free to consider all facts which are brought before me by way of documentary and oral evidence, to the extent they are, in my judgment, relevant, of course, subject to their probative value. Not probation, it's probative value. The effect of the direction contained in the said order of His Lordship, in my humble opinion, is to denude them of their effect for whatever they are worth, but were not meant to treat the facts contained therein as non-existent. In reappraising the decision, the executive director was not, therefore, precluded from taking into account the matter of provision of the contract relied therein as ground of termination referred to in the letter dated 6 June 2018. It is important to appreciate at the outset that the termination of the contract was made on the basis of purported show cause notices dated 2nd June, on the ground of allegation that 3 vehicles detailed therein were engaged by the contractor in transporting coal from Chaurasia siding to RTPS, were caught red-handed while dumping contaminated coal with mud at RTPS unloading point. On such allegation alone, the contract was to be terminated by the respondent's letter dated 6 June, the first letter of termination. When in a further incident of similar nature alleged to have occurred on 1st June 2018 was also mentioned, terming such conduct as corrupt practice and fraudulent practice as per clause 17 DEF of GCC and 24.2.1c of additional special conditions of contract by invoking its power of termination under the aforesaid clause 24.2. Significantly, no show cause notice as to alleged incident on 1st June or any other incident was ever issued. As stated before, the said purported termination order was set aside by order dated 18 June 2018. In this proceeding, we are concerned with the letter of termination dated 5th September 2018. The circumstances leading to the passing of the reasoned order, which was the basis of the issuing the letter of termination dated 5th September 2018, has been adverted to above. I therefore now proceed to examine the validity and sustainability of the reasoned order dated 5th September 2018 passed by Executive Director Project. First, in the reasoned order, Executive Director referred to and discussed the circumstances as illustrative of fraudulent conduct of the contractor pertaining to period prior to 2nd June 2018, including alleged stray incidents of 24th April 2018 and 1st June 2018. Internal investigation by DVC's Vigilance Department and other past incidents. He concluded that the contractor was guilty of fraudulent activities in transporting coal from Chaurasia siding to RTPS and recommended DVC may take a decision for termination of the contract in terms of contract provisions, meaning thereby clause 24.2.1c referred to above. No corroborative evidence was disclosed in support thereof. The inquiry officer also ignored. Well, kindly note, this is very important. No corroborative evidence was disclosed in support thereof. The inquiry officer also ignored the serious objection on the part of the claimant that clause 24.21c of the special conditions of contract, on the basis of which the agreement was terminated, was not part of the contract. I shall deal with the contents of the report and credibility of the extent necessary later in the appropriate context. My lord, I feel that there was some amount of misgiving in the learned arbitrator. He proceeded as if, my lord, what is being questioned before him is the report of the executive director. Because he said no corroborative evidence was disclosed in support thereof. Well, I submit to your lordship that is not so. Because before him, before the learned arbitrator, extensive evidence was given. The persons who had been present at the time of my lord loading of this coal, they had given evidence. They had, my lord, said that I have got the video recording of the thing. The reports are there. They were all tendered in evidence. Kindly note that the learned arbitrator is confining himself to that only. And he says that no corroborative evidence disclosed in support thereof. As if the report of the executive director is the only thing that is before him. That will also appear from here. There is no discussion with regard to evidence at all. Then termination on the basis of express termination clause in the contract, clause 15, paragraph 15. I must therefore consider to what extent the termination of the agreement is sustainable on the basis of clause 24.2.1c of the additional special condition of contract. The additional special condition of contract were really optional terms to be incorporated in the contract at the discretion of TI, a tender inviting committee. There is nothing on record to show that such discretion was ever exercised or those were in fact incorporated otherwise. Had such optional terms been adopted, then by virtue of clause 8 under the general information to bidders, argument could be made that such a special condition in special condition of contract would prevail over terms and conditions, the general conditions of contract. The reason order did not refer to any such document. In the absence of any evidence that those conditions were incorporated by reference, I must be guided by the definition of terms and conditions in clause 1c of the formal agreement dated 30th April 2018, which shall mean that the terms and conditions which are the NIT annual rate contract GCC, which I placed before lordship, and the terms and conditions mentioned hereinafter are binding on the parties. Learned counsel did not seek to refute such contention in course of his argument, beyond saying that those additional special conditions were built in NIT, undermining the importance of the word optional. So, my lord, as far as I could gather, there were the terms, similar terms in various documents. Insofar as this optional additional terms or special terms is concerned, the learned arbitrator, my lord, had, so to say, said that you cannot rely upon it. Now, I am just asking myself this question, why is it so? The reason I tell you, lordship, in these additional special conditions of contract, the termination could be immediate. In the other clauses, 30 days and 60 days notice is to be given. Now, at the most, one can say that if these additional special conditions do not apply, then the other conditions will apply, in which means 30 days or 60 days notice should have been given. Then my respectful submission will be, if that is so, if on that basis one can hold that it is a wrongful termination, then only notice period damages to be paid. So one cannot have, my lord, win, my lord, on both sides. If you say that optional terms will not apply, then you are not entitled to claim damage for more than 30 days. Because, my lord, that is continued. I shall again draw your lordship's attention to that. Whereas, my lord, insofar as the optional terms is concerned, it is immediate. If your lordship, my lord, kindly just look into it. आगे से optional to दाओ. Page 430. হ্যাঁ, প্রতীক দাঁড়াও ভাই। আরে পার করবার সময় দেবে তো তুমি আমাকে। তুমি তো দিব্যি তো কম্পিউটার নিয়ে বসে আছো, চটচট করে বার করছো, আমাকে তো খুঁজতে হবে এগুলো। হ্যাঁ, প্রত্যেকটা জানি আমি, কারণ আমি দেখিয়েছি অলরেডি। Lordship will be pleased to come to that particular clause. The difference kindly keep this open, and along with that, my lord, if your lordship kindly keeps, my lord, the annual rate contract open.
We'll continue, Mr. Mitra.
As your lordship.
It will run in the list at the top of that group.
Well, I'm sorry, this morning your lordship, my lord, waited for me. My matter was called on. I was caught up in the jam because of the rains. Just before I entered into the High Court, the rain started. So I got caught up in the jam.
No problem.
My lord, so long as this legislative assembly is going on, there is a lot of problem for all of us. So we had to walk all the way from town hall to this court. It's good for me. So some amount of exercise is being done. But my lord, I get delayed in coming to your lordship's court.
Hey, লিখে নাও।
হ্যাঁ বলো, তুমি আর কি বলো? না আমার টাইম তো পরশু দিন থাকবে, কালকে তো।
Mr. Jayanta Kumar Mitra, Learned Senior Advocate, representing the appellant, begins his opening submission but does not conclude. Paragraph, list this matter. You want it day after tomorrow? What?
Day after.
Day after?
No, tomorrow, my lord, is the appellate side.
First appellate side, so
First
it will be a little uncertain.
Will your lordship keep it? তো থাকুন না লিস্টে, যদি ডাক হয় তাহলে হোক, আমি তার অন্ত কমপ্লিট করি, তোমাদের যখন সুবিধা আছে। Let it be on the list, my lord, we shall see what happens tomorrow.
List the matter once again, কালকে ডেট দিয়ে দাও।
হ্যাঁ কালকে থাকবে, লিস্টে থাকবে, কিন্তু কালকে তো অরিজিনাল স্যার হবে, মানে না আগে তো অ্যাপিলেট সাইড।
শোনো ইয়ে আমার নোটটা, মেমো অফ অ্যাপিল, মেমো অফ অ্যাপিল।
A short question but interesting question.
Very well. এই ঘুমিয়ে পড়েছে, ঘুমিয়ে পড়ে নর্মালি।
ঠিক মতো গুছিয়ে নি। করো না, জিজ্ঞেস করো না।
My lordship.
আর তুমি দেরি হয়ে গেছে, জিজ্ঞেস করছো, সাহেবকে জিজ্ঞেস করতে হবে। Come to